on this day which has been duly received. Acknowledged by the first party against the separate stamped receipt. So they take another receipt from the defendants 1 to 3. Out of the balance amount, it is agreed between the second party, it is agreed between the party that the second party shall remit the above mentioned 4,52,000 to the BDCC bank. Get released all the title deeds in original. The bank has assured the first party that the original title deeds white deed made at 20th of June would be released on payment of the outstanding due. The tenure for completion, the sale deed is fixed on or before the end of May 1995. Oh, this particular class, the defendants had agreed to sell the property for clearing the loan which was pending with BDCC bank. So 5,10,000 was the agreed amount, out of which the loan that was outstanding was 4,52,000. Out of 75 by 45, they had put up construction by availing this loan. In the frontage, where there was a vacant space, that was agreed to be sold in favor of the defendants, in favor of the plaintiff. With the condition that 4,58,000 shall be paid by them and the balance only to be paid. Yes. So this particular condition was embodied in the agreement itself. Subject to that, the plaintiff paid 40,000 rupees, less than 10% of the advance. He takes a receipt as per Exhibit P3. He has obtained a receipt also for 40,000 rupees. Then he has paid 10,000 and 5,000. That was on 2/2/1995. So 40,000 plus 10,000 by 5,000. Then the plaintiff deposited 1 lakh with BDCC bank. That was on 25/2/1995.
Yes.
Thereafter, on 24/3/1995, he paid another 50,000 rupees. That endorsement Shara has been made on the agreement. That we find it in Exhibit P1. The first one is 2/2/95. 10,000 received 10,000.
All right, up to 24/3/1995, there is no dispute.
No dispute. Now, on 29/5/95.
29 or 25?
29/5.
It's 29/5. $1,50,000.
Yes. That's right. Now, this 29/5/95 payment of 1,50,000 is also alleged to have been paid by cash.
Yes.
Now, he doesn't take any receipt. He says that he has paid it by cash. Now, the plaint government gives a go-by to this. The plaint governments are, insofar as the governments in regard to, may I draw your kind of
sir, just a minute. Sorry to interrupt you. How you can question the payment and transaction between plaintiff and defendant, number one?
Readiness.
Make out the case on readiness.
I am restricting it only for readiness and willingness. That's all.
Readiness and.
Allah,
payment new dispute
payment due ಬಗ್ಗೆ 1,50,000 that he has not produced any document apart from the endorsement. Can I not plead that it is not paid?
No, but you can argue on readiness and willingness. You can substantiate that even if he has succeeded in substantiating even that payment of 1,50,000, you can still demonstrate that this court need not exercise discretionary relief in his favor. On those two counts, you can do it. You can't trust to this transaction, you are not a party.
The trial court has rightly observed,
yes,
in regard to 1,50,000 is concerned. The learned judge says 1,50,000 When he pays 40,000, he takes a receipt. 1,50,000, where was the money for him to pay? He is not an income tax assessee. Then when he entered into an agreement, what was the amount that was available with him? That we get it under Exhibit P15, passbook. Kindly permit me to go refer to passbook. That is Exhibit P15, page 183. As on the date of the agreement, he was holding 36,000 only. That was the amount available with him.
Sir, you can't really look at the actual cash. Is the ability to mobilize fund is the question. Capacity.
That's why I made available that judgment.
And lawyers are capable of mobilizing funds.
Capable of mobilizing.
He has a capacity to mobilize. He may not
Yes,
hold.
even that he has not proved.
Alright.
Where is the document to show that he had means to pay? No. It is well settled. The judgment which that the division bench. Your Lordship was sitting with the division bench. There, that was a case where I argued the matter on behalf of the owner.
You argued.
I lost. That was a case where my client was a billionaire.
Oh, 10 lakhs.
10 lakhs.
ನಾನು ಬರ್ದಿದ್ದೇನೆ ರಿಫಂಡ್ ಬರ್ದಿದ್ದೇನೆ ನಿಮ್ಮ ಪ್ರೇಯರ್
10 lakhs.
ಅದೇ ಅಲ್ವಾ ಇದು ಜಡ್ಜ್ಮೆಂಟ್
ಹೌದು.
What happened to the judgment? This is intact or
I lost the case.
subject to challenge? Is it
No,
challenge?
it is not challenge.
Not challenge.
10 lakhs, his turnover per day was 10 lakhs per day. He was a leading cloth merchant.
Correct.
That was a case where this honorable court held as throughout the conduct of the person would be, this is what the trade law that person seeking benefit of specific performance of contract must manifest that his conduct has been blemishless throughout, so that the court would grant relief on the basis of the conduct of the person seeking relief. Readiness and willingness. The readiness and willingness has to be analyzed on the basis of the conduct of the parties, attendant circumstances, and also evidence on record. Then para 9.
Ali, your client had tampered the agreement.
Huh?
Your client had tampered.
No.
He had altered. Correct. He had made some alterations.
No. What
That's
happened?
why
ಇಲ್ಲ ಟ್ಯಾಂಪರ್
Against
ಮಾಡಿದ್ದಲ್ಲ ಅದು.
ಹಾ.
ಅದ್ರಲ್ಲಿ ಏನಾಗಿತ್ತು ಅಂದ್ರೆ ಸೂಟ್ ಕೇಮ್ ಟು ಬಿ ಡಿಕ್ರೀಡ್. ನಾವು ಬ್ಯಾಲೆನ್ಸ್ ಕಟ್ಬಿಟ್ವಿ. ಯಾರೋ plaintiff deposited the entire amount. Then the defendant filed an appeal saying that he had not given an opportunity. It was remanded. Once after it was remanded, with the permission, I took back the money. So 1 crore which I had deposited, 1,88 lakh, I took it back. That this honorable court finds it fault, saying your conduct in taking it back shows that you were never willing to pay. Therefore, the willingness, which in this case also, as on the date of the suit, as on the date of when he entered into an agreement, he was having 38,000 rupees. That is depicted from Exhibit P15. Then he pays 1 lakh to the BDCC bank. Now, as I read the agreement itself, the condition was that he should clear the loan. The defendants wanted to sell the property because they were unable to clear the loan. Therefore, they agreed to sell a portion in the frontage.
Correct.
So, the main crux of the matter is the defendants were bound to pay the amount to the bank. They were not required to pay to me.
there you may not be correct. Sir, you may not be correct. Because it is his intention. The recitals indicate that why he's selling the property. He wants to clear the bank debts.
Therefore, he wanted to sell.
But post agreement, he says that there is a subsequent development. He says, of course, bank debt is to be cleared, but there's a priority wise, I need that money to perform a marriage. When a vendor requests, the buyer cannot say that under the agreement, I have only agreed to discharge the bank debt and I can't pay you money. That is not how the transactions work out, isn't it?
Could be.
So you can't hold it against
No.
agreement holder.
It is not his case that the contract has been altered. The terms of the contract altered ಅನ್ನೋದು nobody's case.
Contract alter ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ.
Payment ಎಲ್ಲಿ ಮಾಡ್ಬೇಕಾಗಿತ್ತು ಬ್ಯಾಂಕಿಗೆ
Terms of the contract never came to be modified. The terms, the specific content contractual obligation was that he had to pay the loan to the bank.
Then he has elicited in cross examination.
Paying what?
Your argument is covered under the cross examination.
ಏನೋ
ನಾನು ಯಾವಾಗ ನಾನು ದುಡ್ಡು ಕೇಳಿದ್ದೀನಿ ಅವಾಗ ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎಷ್ಟು 10,000 5,000 ಒಂದು ನಿಮಿಷ 10,000 5,000 50,000 ಅದು ಮೂರೇ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿರೋದು. ನಾವು 50,000 10,000 5,000 together makes around 1 lakh of rupee 40,000 area. If so far as 1,50,000 is concerned, why he ought to have paid it to the bank instead of paying it to me. Now, number one, 1,50,000 he has not paid to me, paid to the defendants.
Whether what you are arguing is reflected in the written statement, your vendor has not objected. That stand is not taken by your vendor.
It is taken. It is taken.
Torse.
Written statement.
Allah, he should not have made payment to me in cash. Rather, he should have paid it clear. It is not his grievance.
He has paid only 1 lakh.
Correct.
The remaining amount he should have deposited to the bank.
Correct.
Now, in the plight, he says, I called upon the defendants 1, 2, 3 to clear the loan. He giving a go by to the terms of the agreement. Now, the very color, the stand taken by the plaintiff is contrary to the terms of the agreement.
Order payment to defendant number 1 is contrary to agreement.
No.
That's how it has to be. That is how it has to be read now.
No.
Correct.
Payment of 1,50,000 is not made to the defendants.
And this is a very critical question also. You have raised a valid ground that under the agreement he was required to clear the debt.
Correct. Throughout.
Then clear the debt within the stipulated time. Within
Yes,
this
May 95.
May 95.
Did he do that? No. May 1995 till May 1995, what was the amount that was available with him? As on May 1995, he had 1,30,000 rupees. In April, we see from Exhibit P15, in the month of March, he was having 39,978.
What was the debt, outstanding debt of 4,50,000?
4,58,000.
Yes.
4,58,000. Supposing he had paid me 1 lakh, he paid 1,40,000, 10,000, 5,000, 55 ಆಯ್ತು, plus 50. He paid me 1,05,000. That is admitted. Now the remaining at least he should have credited to the bank. Now 1,50,000 he says he has paid it to the defendants 1, 2, 3. Now Exhibit P1 is the document on which he says that he has made payment and taken an endorsement. Exhibit P1. The defendants file into court Exhibit D1, true copy of Exhibit P1. While effecting payment of 50,000 rupees, it is the case of the first defendant that he received, after he paid 50,000, he took this, he took this signatures. He wanted the signatures of first defendant, defendants 2 and 3, leaving a blank space, saying that he has to incorporate that in respect of payment of 1 lakh paid to BDCC Bank. Now, exhibit P1, when they made payment, exhibit D1 is the true copy which was taken by the plaintiff, by the defendant. Exhibit D1 may kindly be seen. My learned friend brought to the notice of the court exhibit D2. The trial court holds exhibit D2 is tampered, it is not proved. But exhibit D1 is the true copy of exhibit P1. There are two documents here. Exhibit P1 is the agreement entered into between the plaintiff and the defendants 1 to 3. Exhibit D1 is a copy of exhibit P1. Exhibit D2 is the one which the defendant set up a plea, 1 to 3 set up a plea, that when they repaid the entire amount of 2,55,000, 5,000 plus 50,000 damages, the plaintiff returned the original. That according to them is D2. The trial court, after examining, a commissioner was appointed, finds that D2 is tampered. D2 is a document which the learned judge holds that it is not the original which is stated to have been entered into between the plaintiff and defendants 1 to 3. D2 is not the document which is given to the defendants 1 to 3 by the plaintiff, and the contentions of the defendants 1 to 3 that they repaid the amount through their brother of the first defendant has been disbelieved. The court holds exhibit D2 is not the document which they entered into agreement.
Now, if D2 is held to be a tampered document,
Or
why we should not doubt the credibility of this defendant number 1? His conduct is found to be grossly unfair,
quite true,
tampered. He has placed reliance on a tampered document before a court. Now, D1, there is an explanation forthcoming. It's all about probability.
No, the probability, the plaintiff is not overboard. His conduct, kindly consider this. Plaintiff contends that he has paid 1,50,000 by cash. The trial court holds that it is not proved. He is not an assessee. He had no money. The endorsement is by the plaintiff himself, who is an advocate. There is no witness to that. Then the gap is filled up, could be seen from examining exhibit D1. The trial court does that. Therefore,
what exhibit D1 did, D1 and exhibit D1.
The conduct of the plaintiff, first of all, in contending that he makes payment of 1,50,000, how could it be? The court doesn't believe him. Nobody is examined. There is no witness to that. And he has produced the document P2 and 15, where do one their passbook. He had only one account. Where did he get 1,50,000? How did he get it? No.
Whether defendant number 1 made an attempt to get his disputed signatures referred to expert. Whether an attempt was made
No,
by
it was
defendant number
not
1.
done. No, not done. Kindly permit me.
By
D1 may kindly be seen.
ಆಯ್ತು ನೋಡು.
D2 ಅದು ಒರಿಜಿನಲ್, 2 ಒರಿಜಿನಲ್ ಅಂತ ಹೇಳಿ ಕೋರ್ಟು D2ನ this exhibit D1 and P1, the learned judge compares it and finds that it is one and the same. So far as D1 is concerned, the court holds that it is the copy of D1, P1. Now, when 50,000 payment was made, then he insisted for signatures being taken down below, leaving some gap. This gap is filled up.
Yes. ಇದು 1,50,000 ಪೇಮೆಂಟ್ ಇಲ್ಲಿ ಬರೀಲಿಲ್ವಾ?
ಇಲ್ಲ.
ಅಮೌಂಟ್ ಬರ್ಲಿಲ್ಲ ಒರಿಜಿನಲ್ ಅಲ್ಲಿ ಕೊಡ್ರಿ.
ಒರಿಜಿನಲ್ ಅಲ್ಲಿ ಇದೆ.
ಅದೇ ಅಲ್ಲಿಲ್ಲ, ಯು ಶೋ ಇಟ್ ಫ್ರಮ್ ದ ಒರಿಜಿನಲ್. ಅದೇ ಜಸ್ಟ್ ಶೋ ಇಟ್ ಫ್ರಮ್ ಎಕ್ಸಿಬಿಟ್ P1 ಅಲ್ಲ.
It is written by the plaintiff himself.
The signatures are marked through plaintiff.
Signatures.
We admits it. ಇದನ್ನ ಹೇಳಿಲ್ಲ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಅವರೇ ನೀವು. ಇಲ್ಲ ಮರ್ತ್ರಿ. ಅಲ್ಲ, you should have taken me through this. ಅಲ್ಲ, maybe you argued, but you should have.
P1 is not the Xerox copy, it is manipulated Xerox copy. Because the Technical Tenancy exhibit P1 contains the.
ಯಾರು DW1 ನ who admits dependent?
Page 7. In fact, the statement itself can signature.
Signatures ಒಪ್ಕೊಂಡಿದೀವಿ ನಾವು. ಸುಮ್ಮನೆ ಒಪ್ಕೊಂಡಿದೀವಿ.
ಅಲ್ಲ ಸರ್, ಅಲ್ಲಿ ನೋಡಿ. Then how this content goes missing?
That is the crux of the matter.
No, it is for defendant number 1 to explain.
That he has explained in para 6 of the written statement.
ಏನಂತ?
The plaintiff had agreed to tear the entire loan of 4,52,000 within 1 month from the date of the agreement, as the plaintiff had paid only 1 lakh to the bank. That too after 1 month, the bank insisted the defendants 1 to 3 to pay the entire amount in lump sum to get interest concession. The defendants 1 to 3 brought this to the knowledge of the plaintiff and to pay the balance of 3,52,000 to the bank. The plaintiff failed to pay the amount in time. However, during discussion, plaintiff agreed to pay additional advance of rupees 50,000. Accordingly, the payment of 50,000 on 24/3/95 was written, and the first defendant had signed the shara before making the payment. The plaintiff requested the first defendant to put his signature and get the signatures of second and third defendants after leaving some gap. When the first defendant questioned about the same, plaintiff replied that the gap will be utilized to enter the details of the payment made to the bank. The defendant believed the same and accordingly signed the last page of the agreement, leaving some space. At that time, the defendants had retained a Xerox copy of the agreement, and the same is herewith produced as Annexure A. ಇದು ಅವಾಗ ಏನಾಗುತ್ತೆ?
Yeah, but really you have to appreciate the skill of lawyers, sir. Ultimately, it's for the judge to digest but appreciated. The best possible defense.
It is a real
Very inventive, and this court appreciates. Inventive, sir. ಇದು inventive.
ಇಲ್ಲ. It's a fact. ಈಗ exhibit D1 ನನ್ನ ಹತ್ರ ಹೇಗೆ ಬರುತ್ತೆ with the signature blank unless I have tampered, washed it off by keeping something.
Sir, if there are
Could we see that?
now, if there are two originals of one document, you can appreciate it. Xerox ಏನು ಈಗಲೂ ಮಾಡ್ಬೋದು. ಒಂದ್ 2 paragraph ನಿಮ್ ಬಡಾಗಿದ್ದು which really affects you. You can cover it and you can take a Xerox.
Correct.
I'll tell you where your clients, not your client, where dependent number 1 is misled. You should have got rid of the signatures also. You should have got this rid of the signatures. ಇದು ಏನೂ ಇರ್ಲಿಲ್ಲ
ಅದು ಮೋಸ, ಅದು ನಾವು ಮಾಡಿಲ್ಲ. ಇಲ್ಲ ಈಗ ಒಂದ್ ನಿಮಿಷ. ಇದು ಡಿಫೆಂಡೆಂಟ್ಸ್ 1 to 3 ಕೇಸು. 1 to 3, if 1,50,000 was really paid, for a moment assuming that he had paid.
How we are visualizing.
ಅದು ಹೇಗೆ ಅಂತಂದ್ರೆ
ಈ ಪೇಮೆಂಟ್ ಬಗ್ಗೆ ನೀವು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಕ್
ಬರಲ್ಲ ಅಂದ್ರೆ
no, you are not party to this. You were not witness to this document. You were not present when these payments were made.
1,50,000 ಅವ್ರ ಹತ್ರ ಇತ್ತು ಅನ್ನಕ್ಕೆ ಏನು ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ. He was not capable of paying 1,50,000. Assuming that he had paid 1,50,000, as per the terms of the agreement, he should have paid it to the bank. The contractual obligation under
That I will accept.
obligation under P1,
Yeah. The explanation is that para 6 of the written statement.
para 6.
ಅದು ಕ್ಯಾನ್ಸಲೇಷನ್ ದ ಟ್ಯಾಂಪರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆಯಲ್ಲ ಎಕ್ಸಿಬಿಟ್ D2 ದಲ್ಲಿ ಅದ್ರಲ್ಲಿ ಬಂದಿದ್ಯಾ ಕಡೆಗೆ ಇಷ್ಟು ಸ್ವಲ್ಪ ಪೇಮೆಂಟ್ ಮಾಡಿ he was required to clear off the debts of the bank. He has not done it, but he had also secured my signatures in advance, assuring me that he would clear off the debts, and he has not done it ಅಂತ ಆ ಟ್ಯಾಂಪರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಅದ್ರ ಇದೆಯಾ ರಿಸೈಟ್ ಅಲ್ಲೂ
ಇಲ್ಲ.
ಮತ್ತೆ
ಅದು
ಅರ್ಲಿಯಸ್ಟ್ ಪಾಯಿಂಟ್ ಆಫ್ ಟೈಮ್ ಅಲ್ಲ
ಅದು ಒರಿಜಿನಲ್ ವಾಪಸ್ ಕೊಟ್ರು ಅಂತ
ಅಲ್ಲ, ಬಟ್ ಅಲ್ಲಿ ಬರ್ಬೇಕಾಗಿತ್ತಲ್ಲ ಅದು. That was a very relevant piece of material factor.
But the fact is,
when you set up a case, when a narrative is set up, you have to clear all the dots.
all the dots, absolutely. That's what I am asking the plaintiff to do that.
Correct.
Now the dots are, number 1, I deliberately read exhibit P1. There is a clause, there is a preemption clause. This partition, the defendants 1 to 3 got this property.
Yes.
Under a partition deed. There was a preemption clause under clause 10 of the partition deed, para 10, that the plaintiffs, in the event of the defendants effecting sale, the option should be given to their siblings. He has, the first defendant has 2 brothers and a sister.
Yes.
So the partition deed, the plaintiff was aware of that. The plaintiff took the copy of the partition deed, looks into it, he drafts the agreement. He pays 40,000 plus 15,000 plus 50,000, no dispute. So far as 1,50,000 is concerned, the learned trial judge has categorically convinced and held that 1,50,000, if you have really made payment, you would have taken a receipt. You took a receipt for 40,000, mere 40,000. You did not take any receipt. 1,50,000, your passbook does not show that you are having money to that. He had no other source of payment except he has made payment, shown only passbooks. His income, he has not produced any records other than producing the passbook, and then belatedly he makes a sale of the property, produces a copy of true copy. Now, in this background, my humble submission would be the conduct of the plaintiff in not paying the loan to the bank. Is it not a serious concept? When the defendants were under a lot of tension and worry because it was supposed to have, it was being brought to auction. Unfortunately, those records are not made available. So they were deliberate to clear the loan. Therefore, out of sheer necessity, they offered it for sale. Now, what is the conduct of the plaintiff? He pays 40,000, not even 10%. Then, what is the deposit he has made? 1 lakh. That I also admit. For 1 lakh, the balance of 358 was required to be paid by him. Now, what is the effort on the side of the plaintiff as to showing his bona fides as to what is the effort he has made to repay the loan? 358 balance it to. Instead, he says, I paid 1,50,000. You celebrated the marriage of your 2 daughters. Even in regard to that evidence, there is no clear evidence whether he sought loan for the marriage of his daughter. Not clear. The learned judge has also made it clear that in regard to that also there is no proof. But he has made payment of total 1 lakh rupees, 1,10,000. So far as 150 is concerned, absolutely no evidence other than the endorsement.
All.
Now, so far as this endorsement is concerned, 1,50,000,
Yes.
the learned judge has held that he has not proved. Then, supposing he had 1,50,000 paid, even then, he owed the balance payable. What is the record to show that he had money? That is why I may be permitted to read the cross-examination, only 2 pages.
Wait.
Examination in chief, page 25. In page 26, kindly permit me to read 1 para in the chief examination to show the conduct of the plaintiff. The conduct of the defendant is so bad that apart, he has approached the court. Now, chief exam,
Yes.
para number 2. On the date of the agreement at exhibit P1, I paid rupees 40,000 in cash as an advance money. They had agreed that they will clear the loan with BDCC Bank within the period of 4 months and immediately thereafter execute a sale deed in my favor. This is not the case pleaded in the plaint. So, kindly look into the conduct of this gentleman. He gives a go-by to that. He says, no, you have to clear it. Then, kindly permit me to go to the cross-examination. Page 33. I myself drafted the said agreement. I have not done the etc. Para 2. I have gone through the contents of the partition deed before entering into the
Page alli sir?
page 33.
33.
Page 33. Alli, the agreement is drafted by the plaintiff. I myself drafted this said agreement. I have gone through the contents of the partition deed before entering into the agreement. I do not know whether defendants 1 to 3 knows English language. I talked with the defendant only once in connection with the transaction. After the sale transaction, I might have met the defendants 2 or 3 times. It is not true. I was knowing the fact that the defendants were not knowing English language. On the date of the execution of the agreement, I paid rupees 40,000 by way of cash. It was also agreed to hand over the possession of the property before the registration of the sale deed. It is true that there is a recital in the agreement that possession was handed over to me on the date of execution of the agreement itself. Our draft madavaga agreement alli by way of part performance possession is delivered anta kuda barkonbittidare. That he says it was agreed to hand over possession at the time of sale deed. It is true that the recital in the agreement to the effect that possession was handed over to me on the date of the execution of the agreement itself. the witness volunteers that the defendants also agreed to the said recital of the agreement. The defendant signed the agreement, admitting the recital of the agreement in respect of the possession. According to me, defendants handed over possession of the property on the date of the agreement itself. It's very strange. The possession was with the defendant, and the presently it is with the defendants 4 and 5. I have present suit, and I have filed the present suit on the basis of the agreement of sale executed by the defendants. I myself gave instruction to draft the plaint. After knowing the contents of the plaint, I have put the signature. The contents of the para number 11 of the plaint are true and correct. It is not true that defendants never handed over possession of the property to me. It is not true that since myself drafted the agreement of sale, I had written in the agreement for having handed over possession to me just to cheat the defendants. I have acted as per the terms of the agreement. It is true that as per the terms of para 1 of the agreement, I had to discharge the loan of the defendants with BDCC Bank. 4 months' time was stipulated under the agreement for completion of the transaction, except issuing check for 1 lakh in favor of the bank to discharge the loan of the defendants. I had not paid any other amount to the bank within the stipulated period. I have produced the documents before to court to show that I was having sufficient funds with me by the end of May 1995. That is the time duration. I am having the bank passbook with me. As per Exhibit P15, the bank account extract by the end of May 1995, I was having rupees 1,30,921 in my account. I have also withdrawn some of the amounts in the month of May and June 1995. So this was the amount he had. Out of 5,10,000, this was as on May 1995. Earlier to payment of 1,50,000. So what was the balance he had? 1,30,921. So he had paid only 1 lakh to me, 1 lakh to the BDCC bank. So he owed 3 lakhs, and 3,10,000 was the remaining balance. He had only 1,30,000. Even that amount I have withdrawn. Some of the amount I have withdrawn in May, June, and 1995. I had not issued anything in writing before the expiry of the stipulated period immediately after the expiry of the time to the defendants, calling upon them to execute the sale date. The witness volunteers and states that the time was extended. As such, he did not anything in writing. Now his case is, apart from acknowledging 1,50,000, the time is extended till end of December 1995. The witness volunteers said time was extended. As such, he did not issue anything in writing. There is an endorsement on the agreement regarding extension of time. The endorsement effected on the agreement regarding extension of time is P1J. The endorsements are in my handwriting. It is true, first defendant alone signed the endorsement. Even though I asked the signatures of 2 and 3, they did not turn up and sign the endorsement. Whenever I made the payments, the endorsements have been effected. It is not true that I had taken the signatures. So even for that, there is no endorsement. It is true that I had paid 50,000 on 24/3 and obtained an endorsement to that effect. I had not failed to obtain an endorsement in connection with the payment to the bank. It is not true that since I was not having sufficient funds by the end of 1995 May, I asked the defendants to dispose of the property to the third parties. It is not true that I had not paid 1,50,000 to the defendants as per the endorsement P1J. Except the defendants, no other persons were present when I made further advance. Prior to execution of the agreement of sale, I had gone through the Xerox copy of the documents. I had not taken consent from the brothers of the defendant number 1 prior to execution of the agreement of sale. That's because of the preemption clause. I asked the defendants to purchase the stamp paper in my name. Accordingly, the defendants purchased the stamp paper in my name. Prior to purchase of the stamp paper, there were talks regarding the sale transaction. Except payment of 1 lakh to BDCC Bank, I have not paid any other amount to the bank. But the defendants themselves received the amount. As on the date of execution of the sale agreement, I was knowing that what was the amount payable to BDCC Bank. It may be a fact that after payment of the amount to BDCC Bank, the defendants were required to receive rupees 20,000 only. Whenever I asked the defendants at the time of payment of the amount, whether they had paid the amount to the bank, for they replied stating that they had paid the amount to the bank. I do not know whether the defendants agreed to sell the property in my favor as they were unable to clear off the loan to the bank. What is this? This very strange. It is not true that I was knowing then. Next paragraph. Except acknowledging in the agreement having paid finally rupees 1,50,000 to the defendants. I have no other separate documents. The defendants received the said amount to discharge the debt pertaining to the marriage of their two daughters. The defendants have failed to discharge the loan to the bank even though they have received the amount from me. It is not true to suggest that I was not having amount. As such, I failed to get the registered sale deed. It is true that I asked the defendant to sell away the suit property in favor of third persons and to pay the amount to me which was received by them. This sentence is a mistake. Huh? It is true to suggest. Not.
ನೋಡಿದೆ ಅದು ಮಾರ್ಕ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ. ಐ ಥಾಟ್ ಆಫ್ ಕಂಪೇರಿಂಗ್ ಇಟ್ ವಿತ್ ಒರಿಜಿನಲ್ ಅಂತ ನಾನು ಪೆನ್ಸಿಲ್ ಇಂದ ಮಾರ್ಕ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ. Yes, sir.
Then the cross-examination by defendants 4 and 5. No, the defendants 4 and 5, they verified the encumbrance certificate. They purchased the property. They were not aware about the earlier agreement. That is the cross-examination.
Yes.
Then the judgment, kindly permit me to read only those two paragraphs.
Yes.
The learned judge.
Page
256.
Yes, sir.
He takes up additional issue number 1. Additional issue number 1 is whether the defendants 1, 2, 3 prove that the contract between them and the plaintiffs for sale of the suit property was terminated. Now, suo moto, the learned judge, while dictating the judgment, suo moto referred exhibits P1 and D2. We get it at page 260. Page 260. The contention for repayment has been disbelieved. Then para 9. Apart from the alleged document exhibit T2 said to have been delivered by the plaintiff to the DW2, they came to know that the document was fabricated by the plaintiff and given to DW2 by receiving the amount. DWs 1 and 2 asserted in their evidence that it was given by the plaintiff himself. On the other hand, plaintiff denied he has not at all received. The plaintiff produced exhibit P1, agreement of sale pay, said to be executed by defendants 1 to 3 in favor of the plaintiff, and their clear contention that D2 was handed over. Admittedly, defendant, then kindly permit me to go to the next page. Therefore, this court, while dictating the judgment in earlier occasion, suo moto referred P1 and D2 to the FSL Bangalore for getting the opinion of the handwriting expert. Accordingly, the handwriting expert, Lakshmi Narayana, after receipt of P1 and P2, P1 and D2 verified signatures and filed the report. Thereafter, this court summoned the handwriting expert. Accordingly, Lakshmi Narayana examined the CW1, got marked 6 documents. As per the evidence of the handwriting expert, the signatures of defendants 1, 2, 3 on P1, which were the admitted signatures of defendants 1, 2, 3 on D2, that is a disputed signature compared by the expert. He has filed report as per his opinion. The signatures of 1, 2, 3 on P1 and also the endorsement and also the disputed signatures on the exhibit D1 belong to one and the same, and person Ganeshan, Kasamma, Vagnarajan, that is defendants 1, 2, 3. The evidence of the commissioner not been challenged. C1 is the report, C1A is the opinion, C2 is the reasoning, C3 are the admitted signatures of defendant number 1, C5, 6 are the admitted disputed signatures of D2, C7, 8 are the enlarged signatures. Even on a comparison of the signature of plaintiff on P1 and D2, it clearly differs from each other. Even otherwise, I am reading T262 in the Madhyadal. Even otherwise, exhibit D1 is the Xerox copy of the original agreement of sale, wherein the signatures of the plaintiffs are differs from the alleged signatures of on the exhibit D2. Even the letter compared with D1 and D2 differs. Comparison of P1 and D1 clearly goes to show D1 is the Xerox copy of P1.
Correct.
Correct. Other endorsement illa.
ಅದು ಜೆರಾಕ್ಸ್ ಕಾಪಿ ಇದೆ 100%.
Xerox copy ಇದೆ. ಆದ್ರೆ ನಾವು ತೆಗೆದಿಲ್ಲ ಅದನ್ನ. The endorsement is not. Anyhow.
ಅದು ಹೇಗೆ ಸರ್ ಅದು ಮಧ್ಯದಲ್ಲಿ ಒಂದು ಪ್ಲೇನ್ ಪೇಜ್ ಇಟ್ರೆ ಏನಾಗತ್ತೆ ಹೇಳಿ?
ಅದ್ ಗೊತ್ತಾ?
ಅದು ಅಷ್ಟೇ ಅದು.
But if at all exhibit D2 was fabricated, we could either. Issue number 1, kindly permit me to
Yes,
go to
sir.
correct. I should have directly come to that. It is an admitted fact that the defendants 1, 2, 3 are the owners of the scheduled property. They agreed to sell the suit property to the plaintiff for 5,10,000, executed agreement of sale, exhibit P1 on 19/1/95. As on the date of the agreement, the plaintiff paid 40,000 to defendants 1, 2, 3 under exhibit 1, 2, 3 under exhibit P14, receipt acknowledged by the defendants 1, 2, 3. And 40,000 one receipt, exhibit D P14. It is an admitted fact that the defendants 1, 2, 3 mortgaged the property, suit scheduled property to BDCC Bank. There was an outstanding loan of 4,10,000. As per the terms of the agreement of sale, plaintiff required to discharge the said loan to the bank directly, and remaining amount shall be payable to the defendants on or before the registration of the sale deed, and the sale deed should be completed within May 1995. It is an admitted fact that the plaintiff paid 1 lakh to the BDCC Bank directly on 25/2/95. It is also an admitted fact that on 2/2/95 paid 10,000 plus 5,000 to the defendants 1, 2, 3. It was acknowledged by him by endorsing on P1. It is also an admitted fact that on 24/3/95, again the plaintiff paid 50,000 to the defendants. The same was endorsed by the first defendant on the backside of P1. As per the contention of the plaintiff, again the defendant demanded 1,50,000 for the purpose of marriage of the daughter of the first defendant. Accordingly, plaintiff paid 1,50,000 to the defendant, and the same was endorsed by the defendants 1, 2, 3 on the backside of exhibit P1 on 29/5/95. And the defendant also extended the time limit up to December 1995 for execution of the sale deed. As per the contention of the plaintiff, he has already paid 355, request to pay 150 only to the defendants. When the plaintiff demanded the defendant to execute the sale deed, defendants have not executed the sale deed on the ground that they require some more time for discharging the loan. The defendants, though admitted receipt of 2,05,000, denied receipt of 1,50,000 as on 29/5/95. However, the defendant number 1 admitted in the cross-examination the signature found on exhibit P1 and the endorsements belong to them. But the defendant taken a contention while receiving 50,000 on 24/3/95. Plaintiff obtained the signatures of 1, 2, 3 by leaving some space. Thereafter, it was added by the plaintiff showing 1,50,000, whereas plaintiff denied it. Same. In order to prove the contentions of the defendant, they have mainly relied on exhibit D1, Xerox copy of P1. On perusal of P1 and D1, both are same. D1 is the Xerox copy of P1. On the perusal of the last page of D1, it does not show the endorsement said to be made by the defendant number 1, extending the time till December 95. The signatures of 1 to 3 were found on Xerox copy. Comparison of P1 and D1 goes to show that it is obtained signatures of 1 to 3 on the blank space. He has inserted the endorsement said to have been received. It is pertinent to note that on the execution of the agreement of sale, while paying 40,000, plaintiff obtained separate receipt as per Exhibit P14. Such being the case, how a practicing advocate could have paid 1,50,000 only on the endorsement behind the agreement of sale. Apart from that, he has not produced any other document before the court to show that as on 29/5/95, how he got 1,50,000 to pay to the defendants. Even Exhibit P2, the statement of the bank passbook also does not reveal he had more than 1,50,000 in order to pay to the defendants 1 to 3. As per the bank passbook, the plaintiff had 13,208 as on 2/6/95. Even otherwise, for a sake of argument, if we take into consideration, plaintiff paid 1,50,000 as on 29/5/95 for the marriage of the daughters of the first defendant. Plaintiff has not produced any document to show the marriage of the daughters of the first defendant held in May 95 or June 95. Apart from that, as per the terms and conditions of the agreement of sale, plaintiff required to discharge the loan of 4,10,000 directly to the bank. Such being the case, being an advocate, why paid 150 to the defendant on 29/5? Even if he has paid, plaintiff has not attempted to discharge the remaining loan of rupees 3,10,000 to BDCC Bank. If at all he had sufficient money, there is no question of paying the money to the defendant directly. He was required to discharge the loan to BDCC Bank. Therefore, the contention cannot be accepted that he has paid 1,50,000. The bank passbook, but by taking advantage. Admittedly, the endorsement in the handwriting of the plaintiff himself, P2 and P15 bank passbooks are not sufficient to hold that the plaintiff was ready, willing to perform his part of the contract and ready to pay the sale consideration to the defendant, since it is an admitted fact. Then he sells the property in July 95, long after May. Now, supposing he has paid 1,50,000 plus 1 lakh plus 1 lakh, 355 agate alla sir. Even then, if it falls short by 1,50,000 rupees, where is the money? Now, I have no money. Defendants 1 to 3 have no money to discharge the loan. That is why they were frustrated to effect sale. Now, assuming that he has paid 355, what would be the consequence? How to get out of the situation, forgetting that I have purchased? Supposing I had not purchased. Avaga, in which case, who has to discharge the loan? He openly knew all along that he was the obligation for him to discharge the loan. He pays only 1 lakh. The contractual obligation is different and sympathy is different. ಹೆಣ್ಮಕ್ಳು ಮದುವೆ ಕೊಟ್ಟಿರೋದು 1 ಲಕ್ಷ ಒಪ್ಕೋತಾ ಇದ್ದೀವಿ, 40 ಸೇರಿ 1,50,000 ಕೊಟ್ಟಿದ್ರು ಪಕ್ಷದಲ್ಲಿ ಕೂಡ. The remaining 2 lakhs has to be paid to the bank. That is where the learned judge finds fault with the conduct of the plaintiff. In such an event, the learned judge has rightly ordered for refund of the money. Now, specific performance, if it is ordered, then who has to pay the money, get the loan discharged, is the question that would prop up. Unless it is their case that the defendants 1 to 3 said, very well, we will clear the loan. You pay the balance. No, nobody's case. Where is the pleading? The question would be still short of 1,50,000. Therefore, the plaintiff, throughout has shown that he had no money. And he sells it after May 1995. The endorsement says it is extended till December 1995. Why? Why should it be extended when he ought to have paid it to the bank? That is what I could foresee. The conduct of the plaintiff and the defendant's conduct 1 to 3 is maybe another aspect of the matter. Kindly consider the conduct of the plaintiff. He had no money, he has no income other than bare necessities. For purchasing of an immovable property in those days, he ought to have made efforts to show that he had money. He never paid money to the bank. 1 lakh kotru, aladmele kodla illa.
Yes.
So, my humble submission would be this judgment which squarely applies. Throughout, it is necessary that as on the date of this, when he entered into agreement, despite owning a property may not be a criteria. Willingness, ready and willingness. This is what your lordship wrote, considering almost identical case anta ನನಗೆ ಅನ್ಸುತ್ತೆ. Para number 14 and 15. 14. Readiness, willingness has to be analyzed on the basis of the conduct of the parties, circumstances, evidence on record. Then the entire material on record indicates that the plaintiff never intended to keep the contract subsisting, with preparedness to fulfill his obligations and accept the performance when the time for performance arrived.
Para?
Judgment,
The paragraph?
paragraph 14, para 14.
Para 14.
He had opened a new showroom. I had furnished document to show that he was a person of means. Adike, he may have purchased another property.
ಅದೇ ರೆಡಿನೆಸ್ ಇತ್ತು, ನಿಮ್ದು ವಿಲ್ಲಿಂಗ್ನೆಸ್ ಇಲ್ಲ ಅಂತ.
Willingness. That is absent here. That is absent here. Then para 16. If the government same would clinch the entire issue, it is straight law that the agreement holder has to prove his readiness and willingness from the date of agreement till the litigation attains finality. So, as on the date of this agreement, he had only 30 for 40,000 rupees. And the trial court has proceeded on the assumption that he was a big reputed businessman.
Yes, sir.
Then illi 75 by 45 is the total property measurement, out of which he had defendants 1, 2, 3 had constructed ground and first floor, and they were living there, and the frontage matra our sale ಕೊಟ್ಟಿರೋದು. ನನಗೆ the agreement is 33 by 45, out of which he has sold 33 by 30 to the defendants for it. The remaining property is already sold and somebody has already built a construction home.
ಅದೇ we can't accept.
ಅದಕ್ಕೆ ಏನು ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ, ಅವ್ರನ್ನ ಪಾರ್ಟಿನೂ ಮಾಡಿ. No, this is a case where my humble submission would be refund of money is the only relief that could be awarded in favor of the. Otherwise, unfortunately, I am stuck up. I am bona fide purchaser anta ಕೆಳಗಡೆ ಕೋರ್ಟಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ. Nevertheless, We have invested all our life savings over there.
With all grace and politely, you argued for defendant number one.
No, no. I had no other go. I had to support him. Otherwise, I had no other choice. But I have
Correct.
made out a case is my humble submission.
No, I kept on objecting, but you very politely, you took me through all. You really conveniently stepped into defendant number one's shoes. Yes, sir. Noted, I'll examine. ಹೌದು ನೀವು ಅಲ್ಲಿ 3,50,000 ನೀವು ಕೊಟ್ಟರು by May 1995, you were required to clear at least that balance amount, not the entire 4,50,000. Huh? Nimda, got you.
He cross-examined the plaintiff at page 42.
Yes.
What all he said now argued for 1 hour, not an iota of it there in the cross-examination of me.
ಆ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಇತ್ತಾ?
ಇಲ್ಲ.
ಪಾರ್ಟಿಷನ್ ದಲ್ಲಿ
ಪ್ರಿಯಂಶನ್ ಇತ್ತು. ಅದನ್ನ ನಾವು ಕೊಂಡ್ಕೊಳ್ಳುವಾಗ 4 and 5 they obtained NOC from the brothers and sisters pursuant to the preemption clause. That exhibits are produced before the court. So the effort for complying with the preemption clause was there on behalf of the defendants 4 and 5. Whereas the first defendant plaintiff never took initiative. He is not a person who was seriously inclined to purchase. That's why he never did all that.
ತಾವ ಆದ್ಮೇಲೆ NOC ಹೆಂಗ್ ಬಂತು? ತಾವ ಆದ್ಮೇಲೆ ಇಮಿಡಿಯೇಟ್ಲಿ NOC ಬಂತಲ್ಲ?
ತಾವ ಹಾಕಿರೋದು ಕೂಡ after 1 year. ಹೌದು. From the date of the agreement 2006.
December 523 to 1996, within 3 months. Not even 3 months.
Yes, sir.
Now, the learned and my learned and arguing that you have not proved in the marriage, whether somebody was thought from marriage of the thought of the first event. So, like the ladies, doesn't get bored, you have not been able to show that marriage is given of the thought of the first event. So, like the ladies, the application, the cross examination of the at page 52.
ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ ಓದಿದ್ರಲ್ಲ? ಅದು ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಅಲ್ಲಿ ಪ್ರಿಯಂಪ್ಷನ್ ಕ್ಲಾಸ್ ಇತ್ತು. ಅದು ಎಲ್ಲಿದೆ? ಅದು ಮಾರ್ಕ್
Paragraph 10 of exhibit. Partition deed.
Partition deed is part of
P12, para 10. Para 11, sorry. Page 139.
Yes, sir.
Then,
correct.
ಅಲ್ಲ, ಇದು ಒಂದೇ ಒಂದು ಸೆಂಟೆನ್ಸ್. ಇದರಲ್ಲಿ ದಾವಾ ಒಳಗೆ ಹೇಳ್ತಾ ಇರೋದು 1,50,000 ರೂಪಾಯಿ ಕೊಟ್ಟಿರೋದು for discharging the loan incurred for the marriage of the daughters. So this is a new development. 50,000 ಮ್ಯಾರೇಜ್ ಕೊಟ್ಟೆ, ಮ್ಯಾರೇಜ್ ಮಾಡಿರೋ ಸಾಲಕ್ಕೆ ತೀರುವಳಿಗೆ 1.5 ಕೇಳಿದ್ರಿ.
ಒಪ್ಕೊಂಡ್ರಲ್ಲ ಅವರು ಡ್ಯೂರಿಂಗ್ ಟ್ರಯಲ್, ಒಪ್ಕೊಂಡ್ರಲ್ಲ. D1 accepted.
No 150 ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿಲ್ಲ.
ಮದುವೆ ಆಗಿದ್ದು ಒಪ್ಕೊಂತಾರೆ.
ಮದುವೆ ಆಗಿರೋದು ಒಬ್ಬಳದು ಮಾತ್ರ ಒಪ್ಕೊಂಡಿದೀವಿ. ಸೆಕೆಂಡ್ ಡಿಪೆಂಡೆಂಟ್ ಯಂಗರ್ ಸಿಸ್ಟರ್ ಡಾಟರ್ ಗಾಟ್ ಮ್ಯಾರಿಡ್ ಅರ್ಲಿಯರ್. ಸೆಕೆಂಡ್ ಎಲ್ಡೆಸ್ಟ್ ಡಾಟರ್ ಮ್ಯಾರೇಜ್ ಹೇಳಿಲ್ಲ, ಒಪ್ಕೊಂಡು ಇಲ್ಲ. ದೇರ್ ಕೇಸ್ ಈಸ್ 1,50,000 ಕೂಡ ಮದುವೆ ಖರ್ಚು ಮಾಡಿರೋದು ಅಂತ. ಮತ್ತೆ ಇಲ್ಲಿ ನೀವು ಮದುವೆಗೆ ಮಾಡಿರೋ ಸಾಲ ತೀರುವಳಿಗೆ 1.5 ಕೊಡಿ ಅಂದ್ರಿ. ಸೊ ಆಲ್ ದಟ್
ಗೊತ್ತು.
ಮ್ಯಾರೇಜ್ ಮಾಡಿದ್ದು ಒಪ್ಕೊಂಡಿದೆ, ಆವಾಗಲ್ಲ. ಮೇ ಜೂನ್ ಅಲ್ಲ. ನಾವು ಕೊಟ್ಟಿದ್ದೇನೆ ಮಾಡ್ಬೇಕಾ? ಇಲ್ಲ.
Yes, sir. Dictating and reserves.
Okay.
Check. Yesterday.
230 more matters. Srihari.
Where is the government?
Manoj, I appear respond. I appear for response. For 1 and 2, I appear for respondent number 1 and 2, Manoj.
1 and 2.
I did not have any transaction with VRH. Section 226 of the Income Tax Act provides me
Section?
226 of Section 3. Income Tax Act.
You have called out in your repetition? This is not the roster court. Quadri. Quadri 226.
Initiated under chapter 2 of the Income Tax Act or not like that. Normally, when the chapter 2 proceedings for recovery, initiated normally when they have no resort at all to recover the money from the assessee. Only then they go beyond the assessee onto the useful third parties. This is not clear whether chapter 2 proceedings have been initiated or not. I do not know whether the assessing officer or the practical guys. That apart, all are given in section 3. That very
Yes.
the assessing officer or the practical guys. At any time from time to time, I noticed that first money due or money paid interview to the assessing. Or any person who holds or may subsequently hold money or any or the assessing. The assessing officer working for the money revenue or any event.
All right, your case is that your case doesn't fall under subclause 3. Nothing to do with us.
They cannot, for the reason that the associate, the result of human well pursuing, happens to be partner in that fraud, ask me to pay the money.
You are not even remotely connected. Yes, sir.
Manoj, one submission. Manoj, there are 3 parties. Default, Manoj, in this case. the
First
default
you
is-
answer
but-
is, you better answer his first question.
Manoj,
Now whether-
I'll point out from
Is it
their
by-
reply. I'll point out from their reply itself, Manoj, page 62,
Ah.
Annex D.
Ah.
Manoj, may I read?
Page 62.
Please. Manoj. Page 62, Annexure D. This is the reply filed by them. Manoj, point number 1, as it says, I have entered into an MOU dated 11/7/2019 with Rajesh VR and Srimati Nagavalli for development and sale of sites of land situated at so and so. The details of land to be developed as per MOU are so and so. Manoj, in bottom, Manoj, in terms of MOU dated so and so, an advance of 2.8 crores was to be given. This amount is outstanding due as on date. I have no business transaction with Manoj, that is Manoj, they say Sri Vaibhav Patina Sahakara or even Vaibhav Society. Manoj, this is their statement, Manoj, there is no transaction with Manoj. The society is only a conduit, Manoj. The amount is gone from the society, but the actual transaction is between Rajesh and the petitioner herein. Only the amount is gone, Manoj, and there is, and subsequently there is one more reply filed by them, Manoj. I'll point out that also. They file a contradictory reply again at page 66, Annexure F. May I read, Manoj? Page 66, Annexure F. Manoj, in the first reply, they say, Manoj, they have no connection with Vaibhav developers.
Yes.
Manoj, and the MOU also has not been produced in this repetition. Manoj, may I read? I have received a notice under section 226(3) of the Act regarding the payment of tax dues from.
Next line. In this connection, I have to state that in my books of account, so and so is credited as an advance received from.
Please, Manoj, even in the case of Rajesh, Manoj, as on today, Manoj, it's shown as advance given to the petitioner herein, Manoj. It's shown in the books, Manoj, of Rajesh, who is the defaulter. It is shown as advance given, Manoj, and on the society is used only as a conduit, Manoj, for transfer of money. The actual transaction is between the petitioner and Rajesh, who is the defaulter. Manoj, assessee, Manoj, the defaulter, Manoj, has not paid one single rupee. Now, Manoj, we've issued this notice. Rajesh has given advance to him, Manoj, the petitioner herein. We want to recover that advance, Manoj. The petitioner herein simply wants to support the defaulter by not paying one single rupee. And Manoj, kindly see the Annexure G, the notice issued. It was issued on July 19th. And I don't see any urgency suddenly at today. They have not even replied to this notice.
July 19 notice.
Please, Manoj, the impugned notice, Annexure G, your lordships may kindly see the prayer. Annexure, they have not even replied. Straight away, they have come before your lordships.
Yes.
And then, Manoj, what? I'll make myself. Manoj, I'll read the Annexure G, which is impugned before your lordships. Manoj, page 86. This is the notice issued, Manoj, last and 68 Annexure G.
Yes.
Manoj, it's 70 is the relevant portion, Manoj. In contradiction to the facts already submitted by you, you have.
Where are you reading?
Manoj, page 70, starting Manoj 3.1 para. Manoj, the first, it starts from para 3. In contradiction to the facts already submitted by you, you have, by submission dated 5/6/2024, claimed that certain amounts were returned on various dates before year 2022. Your aforesaid submission is not backed up by any evidence or bank transfers, but only through ledger account extracts, which is unverifiable in absence of supporting evidence. You have not submitted any bank statement showing repayment of money by you to any of the persons. Further, you have claimed that you have received check from Sri Vaibhav Builders and Promoters. In the caption notice 226(3) of the Act, it is clearly mentioned that the amount of money owned by you to Rajesh,
Any
Nagavalli.
precipitative action is contemplated in coming 2 days.
my lords, my lords, this notice is defaulted.
Sir, I've got another two, so my roster, two parted matters, we are at 4 o'clock. I have to hear it today. Any urgency, can't you wait till Monday?
My lords, let them file a reply to this notice. My lords,
Then why you're not replying to this? Why you straight away rush to the court? Where is the reply? Where is the reply? You can't, no need to visit the department. You have to tender your reply. Why you're not replying?
my lords, that is, my lords, they admit that my lords, they admit that they have received the advance money.
See, 16/5/2024 order. You have kept quiet till now. When this was filed? Huh? You filed?
My lords, everything.
No, it requires.
They have not submitted any of these documents, your lordships. In the impugned order, we've specifically asked submit all these details. They've never submitted any. Before your lordships, they come
Wait.
straight away.
He says,
My lords, we've recorded specifically in Annexure G. Your lordships may kindly see, my lords.
no, Monday, please. Sri, what's your name? Monday. List
Serial number 2,
List it. No. No.
serial number 2, Rajesh
No.
PN.
List,
Obliged.
Monday. No, not an urgency, sir. Yes, next, Rajeshwara. Any urgency? Why you moved it? It's only attachment. It's only attachment order. It's only attachment order, Tane. All right, go and file the objections, seek vacation of the order. Nothing has happened, it's only attachment after award, Allah. Before, all that, what is the remedy to you then? No. No. Dispute is raised by whom?
The safety of my vendor is a period 2015 years. The dispute raised by one of the members of the society before.
Prefer an appeal, why you come before this court? So what? Make it a ground. Make it a ground. You can't go on filing writ petition before this court. You have a remedy, efficacy remedy. What is this? And what will happen? What has happened? There is an attachment order, that's all. That's not put to sale, no. You give an undertaking and seek modification of the order. Go before the court. No. Simply because you file a writ petition, no stay, no interim orders can be. No, this is not the way to, you have a remedy, efficacy remedy. No. Not in such cases, madam, not in such cases. Not in such cases. And you know that it is appealable and you come and file a petition here. You should have advised your client to file an appeal. Yeah, provision covered appeal.
They have filed an increasing application, there is no order in increasing application.
Nothing will happen, madam. There is no urgency. You should not have moved it at 2:30. It's an attachment order. You could have challenged it. I can understand the sale proclamation, sale, other I can understand. Award agilla. Huh? Yes, madam.
There is an alternative remedy. Wala.
That's all. Huh? Quote 105, quote no. Yeah, this is passed under what? 103 order.
Please.
It violates subclause 2 of 103. Huh? Subclause 2.
Attachment made under this section shall not affect the right successful cleared in attachment of the property. A person is not party to the proceedings in connection.
No. Procedural error, according to
106 provision, my lord. 106.
ಏನು 106.
Appeal to the.
Allah, madam, this attachment order is passed in violation of procedure contemplated under subclause 2 of 103. Court, you have the counsel for petitioner, Leonard AG is directed to. He directed to accept notice to respond number 1. Prima facie, this court is satisfied that the attachment order passed by first respondent Allah. First respondent clearly contravenes the mandate enumerated under subsection 2 of section 103 of Karnataka Cooperative Societies Act 1959. Petitioner is aggrieved by the order as the same is not preceded by an opportunity of a show cause notice which is contemplated under subclause 2 of 103. Matter requires consideration. In that view of the matter, same is stayed till next date of hearing. Odbardu, Adre,
Say number 3.
issue emergency notice to 2 to 4.
Sanjay ready? Sir ready?
Yes, sir. Ready, sir. Here is urgency.
ಟ್ರಾನ್ಸ್ಫರ್ ಸರ್ಟಿಫಿಕೇಟ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ.
What is the main relief?
ಮೇನ್ ರಿಲೀಫ್ ಅದೇನೆ ಬಟ್
ಇದು mandamus ಅಂತಿದೆ ಈಗ.
ಅಲ್ಲ ಯಾಕಂದ್ರೆ ಲಾಸ್ಟ್ ಡೇಟ್ ಆಗೋಗುತ್ತೆ. ಯು ಲಾಸ್ಟ್ ಮೈ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಕೊಡಿ ಸಮ್. ಐ ವಿಲ್ ಟೇಕ್ ನೋಟಿಸ್ ಟು
ಯಾರಿಗದು?
2 and 3.
Under the AGA is directed to accept notice to respond number 1. Petitioner issue emergency notice to respondents 2 and 3. Simultaneously, petitioner is permitted to take notice by way of hand summons on respondents 2 and 3.
2 and 3.
Returnable by
ಮಂಡೇ
Monday na.
ಸರ್ವ್ ಮಾಡ್ತೀನಿ ಆಮೇಲೆ
Monday, release this patent preliminary on
ಪಬ್ಲಿಷ್.
Say number 4.
4.
Petitioner, my lord, the interim measure sought is, the main relief sought is, my lord, for mandamus for the revenue and planning authorities to clear the illegal layout. My lord, even according to the Revenue and Planning authorities, it is a illegal layout. Multiple notices are issued by the Revenue authorities, DC's office, as well as MUDA, that clear the illegal layout and as against private respondents. My lord, there is a title dispute pending between the petitioners and the private respondents. It is pending since 2016. They apply, my lord, for conversion, deemed conversion they obtain. Subsequently, rightly or wrongly, my lord, the DC cancels the conversion order. And the planning authority says they have not at all issued any plan, sanction plan.
You moved it at 2:30.
My lord, they're building now, my lord, they're starting construction. It will prejudice 2000, my suit, my lord, title suit is pending.
Take notice.
My lord, private respondents, my lord, at least until next date of hearing, let them stop construction, my lord, because right from 2016, title suit is pending, my lord, and they suppress all these
Don't know,
things.
we don't know. ಇದು ಬಂದು ಇಂಜೆಕ್ಷನ್ ಇಲ್ಲಿ
My lord,
226 ಅಲ್ಲಿ ಇಂಜೆಕ್ಷನ್.
my lord, I have filed in pleading application, I have filed 39(1 and 2) before the trial court, it's
No,
still pending, my lord, still
You
pending.
can't maintain a writ petition. What is this?
My lord, my rights in the property would be
Court
serious.
ಎಲ್ಲ you are converted into
My lord,
a general court where all reliefs are sought before this
my
court.
lord,
by
even
filing.
according to the planning and revenue authorities,
A
my lord,
suit is pending.
suit is pending, my lord,
That's
no
the
doubt, my
best,
lord.
best place to seek injunction.
My lord, I filed an application, my
Then
lord,
you
they're trying to
insist-
drag on the matter, my lord. Now, my lord,
No,
my lord,
cut this.
my lord, my submissions, even according to the revenue and planning authorities, as per exhibit P1 to P3 and exhibit PQ, my lord,
You are
and
seeking
annexure, my
injunction.
lord, sorry,
You are seeking injunction, mister.
not injunction, my lord, my lord.
Not to
please
construct ಅಂದ್ರೆ ಏನದು?
not to change the nature of suit, my lord,
ಅದೇನದು?
as regards the,
ಏನದು? Virtually injunction.
otherwise, my lord,
And
it
your
will
suit is
frustrate
pending.
the
Is
trial.
it a comprehensive suit?
The comprehensive suit is filed, my lord, it is pending.
When
from
you filed the suit?
2016, my lord, they were the ones who filed it, my lord. They were the ones who filed it, private respondents.
NRDJ directed to accept notice to respondents 1 to 5. Issue a major notice to respondents 6 to. Notice ಅಷ್ಟೇ ತಗೊಳ್ಳಿ 6 to 13.
Lord, and at least until next
ಅಷ್ಟೇ
date of hearing.
notice, notice.
Lord, at least till next date of hearing, my lord, I have
No, no,
produced
sorry.
photographs, my
No,
lord.
no. Without examining, we can't, sir. We don't know why you are not granted
This
injunction.
date may be fixed for
2016.
consideration of interim prayer, my lord, after vacations, my lord,
Release this matter preliminary on so and so date.
for consideration of. interim.
The question of, the interim, consideration of interim order will be examined on the next date of hearing.
Date may be fixed after vacations.
Date ಕೊಟ್ಟಾಯ್ತು.
25. Number 5, Banu Prakash, HV Banu Prakash.
Yes, sir.
For petitioner, this is election matter, cooperative, milk cooperative election matter, without my name mentioned in the voter list, they have conducted the election, election petition,
ಎಷ್ಟ್ ಜನ ಇದ್ದಾರೆ ವೋಟರ್ಸ್?
voters 160 members,
ಆ
160 members, sir.
They are not challenged to provisional list. I have already announced.
Announce.
Final list.
ಯಾವಾಗ
also
ಆಗಿದೆ ಅದು ಅನೌನ್ಸ್?
that time.
Recent, no
Recent.
notice has been given.
Even calendar of event is issued. That themselves,
When the elections are scheduled?
610 members,
6:10 ನಾ?
610.
Already listed on Monday?
Why? Nomination get day after tomorrow last statement. At least permit to conduct the election, inserted my name in the.
Election ಆಗಿಲ್ಲ. You can only participate subject to what?
they are actually, their contention is administrator appointed. That case is pending before DRT. That is the reason.
DR.
DR. DR, that is the reason they have come before the honorable court stating that they are not allowing, because as per section 28B2, they are not eligible to contest the, vote.
Why? ಏನ್ ಹೇಳ್ತದೆ 28? 28B2.
They were failure to conduct the election, my lord.
That's why we filed appeal before the DR, my lordship. Direct conduct the election anta. That is our appeal.
ಏನೀಗ ಇದಕ್ಕೂ ನೀವು ಎಲೆಕ್ಷನ್ ಪಿಟಿಷನ್ ಹಾಕ್ಬೇಕ್ರಿ. What is the latest judgment on this point?
ಇದರಲ್ಲಿ ಜನರಲ್ ಬಾಡಿ ಮೀಟಿಂಗ್ is conducted on 25/9, my lordship.
Provisional list ಯಾವಾಗ ಇಶ್ಯೂ ಆಗಿದ್ದು?
5/8, my lordship. 5/8 ಅಲ್ಲಿ.
You have not objected. You have not challenged that.
The appeal is pending. The
Huh?
appeal is pending before the deputy registrar, my lord.
Now also
Then-
it is pending, my lord. Today it was posted, but they are not appeared.
ಅಲ್ಲಿ ಅಪೇರ್ ಆಗಿಲ್ಲ. ಅವ್ರು ಇಲ್ಲಿ ಅಪೇರ್ ಆಗ್ತಾ ಇದಾರೆ.
ಅಲ್ಲ ನಿನ್ನೆ ಜನರಲ್ ಬಾಡಿ ಮೀಟಿಂಗ್ ಪೊಲೀಸ್ ಫೋರ್ಸ್ ತಗೊಂಡು ಜನರಲ್ ಬಾಡಿ ಮೀಟಿಂಗ್ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ. ಏನೋ ಪರ್ಮಿಟ್ ಟು ಕಂಡಕ್ಟ್ ದಿ ಎಲೆಕ್ಷನ್ ಮೇಲೆ
ಕಾಂಟೆಸ್ಟ್ ಬರಲ್ಲ. ನಾನು ವೋಟಿಂಗ್ ಅಂದ್ರೆ ಐ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಸಪರೇಟ್ ಬಲಾಟ್ ಅಲ್ಲಿ ಇಟ್ಟು ಮಾಡಿ ಅಂತ ಸಬ್ಜೆಕ್ಟ್. ಟೋಟಲ್ 160
ವಿತೌಟ್ ರೀಸನ್
160 ಮೆಂಬರ್ಸ್.
ಹೌದು 147 ಮಾಡಿದ್ರು ಸ್ವಾಮಿ. ಅವ್ರು ಏನ್ ಮಾಡಿದ್ರೆ ಪ್ರೀವಿಯಸ್ ಯಾರ್ಯಾರು ಮೆಂಬರ್ ಇದ್ರು ದೇ ಆರ್ ಮೆಂಬರ್ಸ್ ಲಿಸ್ಟ್
Challenge it by way of election disputes. We will not stall the elections.
ಅಲ್ಲ ಕಂಟೆಸ್ಟಿಂಗ್ ಪರ್ಮಿಟ್ ಟು ಕಂಟೆಸ್ಟ್ ದಿ
No. You are not eligible. Your list ಅಲ್ಲಿ ಇಲ್ಲ.
ಇಲ್ಲ.
ನೋ ಜನರಲ್ ಬಾಡಿ ಮೀಟಿಂಗ್ ಇಸ್ ಕಂಡಕ್ಟೆಡ್ ಸಿನ್ಸ್ ಫ್ರಮ್ 1 year my lords.
ಅದನ್ನ ಎಲ್ಲಿಗ ಈಗ 226 ಅಲ್ಲಿ ನೋಡಕ್ಕಾಗತ್ತ? 28B ನಾ? Madam?
Please, my lord, 28B2.
ಏನು, this is a kind of disqualification.
My lord,
Disqualification, no notice has been issued, nothing.
filed an objection before the DR, my lord.
Elections are not conducted before expiry.
No,
Before expiry of period of election conduct
ಇಲ್ಲ
ಮಾಡಿಲ್ಲ.
ಮಾಡಿಲ್ಲ.
ಅದಕ್ಕೆ they have incurred a disqualification.
Correct.
ಇವ್ರು ನಿಮ್ದು ಟೆನ್ಯೂರ್ ಯಾವ ಮುಗೀತು? ಇವರು ಆಲ್ರೆಡಿ ದಿ ಆಫೀಸ್ ಬೇರರ
ಹೌದು 15/7/23 ಮುಗಿತದೆ.
ಮುಗಿತದೆ.
ಹೌದು.
Law what 28B mandates that you have to conduct. GM ನೀವೇ
ಅಲ್ಲ
conduct ಮಾಡಿ.
DRS appointed administrative officer.
DG.
That is the reason DRS administrative appointed administrative officer. My lords. We are no, that's why we filed an appeal before the DR.
Why-
We filed an appeal on
Within time period, the administrator is,
they have not conducted.
The expiry administrator is
ಹೌದು.
appointed. Then you have already incurred a disqualification.
No, my lords, we filed an appeal on July 9, my lords. Appeal ಸುಮ್ಮನೆ ಲಾಂಗ್ ಆಗಿ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. It permit to conduct the election and contest the election, madam. Voting and contest. Do not they not give any notice to us, which is
We can't permit you. ಈಗ ಹೆಂಗ್ ಪರ್ಮಿಟ್ ಮಾಡಬರ್ತದೆ?
day after tomorrow nomination filing last date.
Participation I can understand, not contesting. Contesting ಬರಲ್ಲ. ನಮಗೂ ಪರ್ಮಿಟ್ ಮಾಡಿ ಟು ಪಾರ್ಟಿಸಿಪೇಟ್ ಅಂಡ್ ವೋಟ್ ಅಂದ್ರೆ ಐ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಸಪರೇಟ್ ಬ್ಯಾಲೆಟ್ ಅಲ್ಲಿ ಇಡಕ್ಕೆ ಕೇಳ್ಬೋದು.
ಅಲ್ಲ, it is a right of the God without notice, my lords.
No, we can't permit you to contest. This is
Okay,
too much of us.
committees, how can you conduct the my lords?
ಆಯ್ತು, ಅದನ್ನ
The
election
administrative officer is appointed, they are duties.
ಅದಕ್ಕೆ
That's why if I
ಅದಕ್ಕೆ ಎಲೆಕ್ಷನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಹಾಕೊಳ್ರಿ. I'll permit you to cast vote. ಅದು ಬರಲ್ಲ ಈಗ, ಡಿಸ್ಕ್ವಾಲಿಫೈಡ್ ಅಲ್ಲ. ಅದನ್ನ ಮಾಡ್ಬೋದು, ಸಪರೇಟ್ ಬ್ಯಾಲೆಟ್ ಮಾಡಿ. ಟೋಟಲ್ 160 ಅಲ್ಲ? 160 ದಲ್ಲಿ ಇವ್ರು ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ? ಎಲ್ಲ ಆಫೀಸ್ ಬೇರರ್ಸ ನೀವು?
ಹೌದು, 5 ಜನ ಇರೋದು ಹಿಂಗೆ ಆಯ್ತು. 5 members.
ಏನ್ ಇದು ಸರಿ ನೀವೇ ಕಂಟ್ರೋಲ್ ಮಾಡಿ ಇಡ್ಬೇಕಂತಿದ್ಯಾ?
the
ಅಲ್ಲ, ಆ ಥರ
petitioner
Now,
verified
you are
the-
contesting the election, vote ಯಾರು ಆಗ್ತಾರೆ ವಿನ್ ಆದ್ರೆ ಇಲ್ಲ ಸರ್.
I'll permit you to cast vote if you want. Otherwise, just notice. ಯಾರು ಏನ್ ಬೇಕು? ಅದ್ ಮಾಡ್ಬೋದಾ? ಸಪರೇಟ್ ಬ್ಯಾಲೆಟ್ ಅಲ್ಲಿ ಇಟ್ಬಿಡಿ, ಮತ್ತಿನ್ನೇನ್ ಮಾಡ. And if that differential is if the less than margin ಇದ್ರೆ then it becomes inconsequential. ಮಾಡ್ಬೋದಾ? ಏನ್ರಿ?
ಅಲ್ಲ, ವೋಟಿಂಗ್ ಕೊಟ್ಟ ಮೇಲೆ ಎಲೆಕ್ಷನ್ ಕಂಟೆಸ್ಟ್ ಮಾಡಕ್ಕೆ ಪರ್ಮಿಷನ್.
ಅದಕ್ಕೆ ಬೇಡ ಬರ್ಕೊಡಿ. Leonard is directed to accept notice to respondents 1 and 2 na vote permission.
Please, ma'am.
Issue emergency notice to respondents 3 to 5. The elections scheduled on your date.
6/10.
6/10 will be subject to outcome of the writ petitions.
ಅಲ್ಲ, voting for our ಕೊಡಿ.
ಬೇಡ. Next.
Otherwise, Monday ಮೇಲೆ ಅಷ್ಟೇ.
ಮಾತಾಡ್ ಕರೀಲಿಲ್ಲ. ವಿಷಯಗಳು ಕರೀಲಿಲ್ಲ.
These two serial number.
And ಸಮಸ್ಯೆ ಮಂಡೆಗೆ.
All right, ಮಂಡೆಗೆ ಹಾಕ್ರಿ ನೋಡೋಣ.
Issue and summons to Monday.
Emergency notice ಅನ್ಬೇಡ್ರಿ. Petitioner is permitted to take notice by way of hand summons to private respondents returnable by Monday, listed in implementing on Monday.
Dictator serial number 1. Balakrishna Shastri.
Yes, madam.
Yes. I appear for respondents 3 to 9.
3 to 9.
3 to 9. They are the,
ಹೌದು ಇವತ್ತು ಆಗಲ್ಲ. You need not wait. Monday, Tuesday ಆಗಲ್ವಾ? ಎಲ್ಲಿ ಸಂಪತ್? Monday? Monday 2:30.
Serial number 10, sorry. Last one.
ನಮ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ. ಬರ್ಬೇಕಷ್ಟೇ. ಕೇಸ್ ಕರೆ ಒಂದೇ.
I was here, sir.
ಅವ್ರು ಬರ್ತಾರೆ, ಅವ್ರು ಕಲಬುರ್ಗಿ ಬರ್ತಾರೆ ಅನ್ಸುತ್ತೆ, ಅವ್ರ ಜೊತೆ ನೀವು ಬಂದ್ಬಿಡಿ. ಮಾತಾಡೋದ್ ತಗೊಂಡಿದ್ದೀನಿ ನಾನು, ಇಲ್ಲ
ನಾನು ಆಲ್ರೆಡಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದೀನಿ, ಡೀಟೇಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗ್ತಿದೆ, ಅರ್ಧ ಜನಕ್ಕೆ
ಪಾಠ ಮಾಡಿ ಸಮ್ ಆರ್ಡರ್ ವಿಲ್ ಪಾಠ ಇಟ್ ಇಸ್ ಟ್ರೀಟೆಡ್ as ಪಾಠ.
ನಾಳೆ ನಾಳೆ
Ah?
ನಾಳೆ ನಾಳೆ
Tomorrow virtually I'm not sitting. Monday, Tuesday, we have only 2 days on hand and what? All right. Respondents, madam, 3 to 9,
3 to 9.
3 to 9.
The prayer sought in this writ petition at page 17, my lords. Issue a writ of certiorari quashing the order of the land tribunal, respondent number 2, in LRF number 1 of 7980, dated 13/7/1982. The writ petition is filed in the year 2016.
2016.
16.
Land tribunal order is dated
13/7/1982.
13/7/1982.
After a lapse of more than 34 years.
Yes, madam.
Now, I would like to take your lordship to the order in LRF 1 of 7980 dated 13/7/1982. The chairman and members are present, and Munyappa alias Doomanna is the petitioner.
Where you find it? At page number?
Page 46 from
Page
of,
40.
yes, of the writ petition, my lords. Okay, okay, I'm sorry,
Yes.
I'm sorry. Twenty-eight of the writ petition, my lords. Page 28, annexure B.
Page 38 and
It's a handwritten order,
Also,
38.
handwritten order.
38 typed copy.
typed
Page 38.
order. The typed copy is there, madam.
Yes, my lords. The first, the petitioner is Munyappa alias Doomanna. The
Yes.
first respondent is Muniswamappa, son of Doomanna. Muniswamappa. R2 is Hemanna, son of Muniventa. R2, the LRs of R2 are before your lordship in this writ petition.
This is the order under challenge now?
Yes.
Yes.
I would like to take your lordship to the entire order because this is the base of the, on 17/1/1979, the petitioner filed an application in Forum 7 praying registration of occupancy rights under Section 48A of the Karnataka Land Reforms Act 1961 as amended in respect of 2 acres 8 guntas in survey number 6 and 1 acre in survey number 4 of Satnur village, Jalahobli, Devnalli Taluk. He has impleaded first respondent Muniswamappa as landlord. His application was accompanied by an affidavit to condone the delay in filing the application. Subsequently, on 4/7/1979, the petitioner filed one more application to implead the second respondent, Hemanna. He has been impleaded on 4/7/1979.
Yes.
As party to the proceedings and to proceed with the case. Again, on 12/7/1979, third petition was filed seeking orders of the tribunal under Section 48C of the Act, requesting the tribunal to issue orders of temporary injunction, restraining the second respondent, Hemanna, from interfering with his peaceful pursuit and enjoyment of these lands. In support of his claim, he had produced extract from the RTC pertaining to the survey numbers claim. Individual and public notices were served and published in the village. And on the respective parties, in response to this, the petitioner and the respondent Hemanna appeared before the tribunal on 12/7/1979. The tribunal recorded the statements and examined the certified copies of RTC produced by the petitioner for the year 68/69 to 78/79 and took decision to appoint the revenue inspector Jalahobli to be receiver of these lands under Section 48C1 of KLR Act. Notice to first respondent could not be served. This is important, my lords, as his whereabouts were unknown to the tribunal. Because this
I've
is
already marked it.
yes,
I have marked it. Your father,
that's it.
your father has gone missing.
Yes, he's gone missing at the day to this one. Since 69, he's gone missing and that is the evidence on record. Agreed by the orders of the land tribunal, the second respondent Hemanna filed writ petition number 12045 of 79 before the Honorable High Court of Karnataka. The Honorable High Court in the writ petition 12045 of dated 6/11/1979 was pleased to modify the orders of the tribunal and appointed second respondent Hemanna himself as the interim receiver of these lands till the disposal of application filed in forum number 7 by the petitioner Sri Dumanna with the directions to deposit the value of crops after detecting all expenses incurred by getting necessary instructions from the tribunal from time to time in the management of these lands. The second respondent thereafter is continued to be the interim receiver of these lands under the orders of the Honorable High Court of Karnataka. The lands are now in possession of the second respondent. The tribunal proceeded to conduct inquiries on 11/12/80. The second respondent, Hemanna, filed his written statement. He has stated that he is the owner in possession of the lands claimed by the petitioner. He admitted that these lands originally belonged to the first respondent, Muniswamappa, who is none other than the father of the petitioner. He has admitted that according to partition among the petitioner and his brothers and his father, the lands in question fell to the share of the petitioner's father, Muniswamappa. The said Muniswamappa borrowed 2 items of loan from Primary Land Development Bank, Devnalli, on 13/8/65 and on 29/11/65 on the security of these lands and became the defaulter. In order to realize these 2 items of loans, these lands were brought to sale and put in auction on 17/4/1978 by the PLD Bank, Devnalli, and the respondent Hemanna got these lands as the highest bidder in public auction. The sale was also confirmed by the Assistant Registrar of the Cooperative Societies, Doblapura, on 12/12/78, and the fact was also notified in the Gazette dated 28/12/78. He further states that he has been in possession of these lands ever since the date of sale from 28/12/1978. Earlier it has been, he has been appointed as the interim receiver only by this honorable court on 6/11/1979. Here he says he has been put in possession under the sale deed dated 28/12/78. The respondent that for the reasons quoted in his written statement requested the tribunal to dismiss the prayer of the petitioner in the instrument. On 23/12/81, the petitioner filed his written statement stating that these lands bearing survey number 4 and 6 of Satnur originally belonged to the joint family of the petitioner, his father Muniswamappa, first respondent, and his brothers Avlappa and Chinnappa. There was a partition of these lands on 7/9/1965 anta ide Swamidu. The document is produced by the petitioners. It is 1955. The document is
7/9/1955.
55. They have filed a set of additional documents
Yes.
on 28/11/2016. And partition deed, which is a registered partition deed of the year 1955, is produced at page 44 of the additional set of documents produced by the petitioners.
So you admit that these are ancestral property.
Ancestral and divided.
Correct.
Division has taken place here.
Correct.
And I would like to take your lordship to whether a petition by forum number 7 by a son against the father is maintainable is the point that happened. Yes. The definition under the Land Reforms Act, section 212,
Family.
Family minor sons and unmarried daughters, and of course the husband and wife.
Good. Land Reforms Act.
I would. Family. In the case of an individual who has a spouse or spouses, such individual, the spouse or spouses, and their minor sons and unmarried daughters, if any. And there is also a judgment of this honorable court definition, section 212 ಬರೆಸಿ.
Yes.
So it is only spouses, the individual spouse or spouses, and their minor sons and unmarried daughters.
This definition is in context of a tenant's family or a landlord's family?
ಯಾವುದಕ್ಕೂ ಇಲ್ಲ ಅಂತಾನೆ ಇದೆ ಸ್ವಾಮಿ. There is no definition with regard to whether
It is in context of a tenant's family,
tenancy. Tenants.
not a landlord.
ಇಲ್ಲ landlord ಅಲ್ಲ, because Land Reforms Act tenancy.
By applying, madam, by applying this definition,
Yes.
you want to exclude a son of a joint family, a landlord's family. Can you exclude by applying this definition?
Yes, because the tenancy is in respect of the land.
Now,
If I file forum number 7,
you're trying to lay a foundation on the ground that son in this case is a major son. Therefore, he doesn't become a part of a family as defined under section 212.
yes,
And therefore, he's an outsider.
not an outsider.
The
There has
context
been
of future.
partition. There has been partition
Partition, yes.
Yes, partition, and there is division, and therefore the son can maintain
No, no.
a petition.
Partition is between his father and his uncles.
No. Even the petitioner,
He is also.
his father, his brothers, and the petitioner. Petitioner is a part of the partition.
He is allotted some other land.
Yes, some other land, and these two lands were allotted to his father.
And when the lease, when he was inducted as a tenant?
After 2-3 years anta order bandide Swami. Very same order that.
No, what is the date of, when he was, form number
After
7?
partition,
Let us
he
see.
cultivated, yes, man.
Form number 7. We'll see your form.
Forum number 7, yes, my lords. ಇಲ್ಲಿದೆ. The very same set of documents furnished by the other side.
Yes, where is the form?
Dated 28/11/2016 ಅಲ್ಲಿ one set of documents ಹಾಕಿದ್ದಾರೆ, additional documents. ಅದರಲ್ಲಿ
Records ಇಲ್ವಾ? Form number 7.
page 12 and 13 ಇದೆ, 11 and 12.
Only one land, madam?
Two lands.
Two lands.
Two lands. And not the entire. One survey number is the entire extent 2 acres, 8 guntas. Another, only 1 acre out of 3 acres, 21 guntas. The remaining land, 2 acres, 21 guntas, are in the possession of the petitioners. They have purchased that land also under the very same auction. And they are in, even today, they are in possession. That is not, yes, that is not challenged. Forum number 7 ಅಂತ ಇದೆ ಸ್ವಾಮಿ ನಮಗೆ ಕೊಟ್ಟಿರೋದು.
Yes. Let us see the RTC. RTC is from 1956 to 74.
56 ಇಂದ ಇಲ್ಲ ಬರಲ್ಲ ಸ್ವಾಮಿ. It's only after 68 RTCs.
ಯಾಕೆ?
ಅಲ್ಲಿಗೆ ಮುಂಚೆ RTCs ಬರ್ತಾರೆ. 68 ಇಂದ onwards RTC. That is also furnished. And
ಶಾಸ್ತ್ರಿ ಸರ್,
series I have. Annexure V series I have produced.
ಇಲ್ಲ ಬಟ್ ಇಲ್ಲಿ RTC ಇಲ್ವಾ?
RTC
ಇಲ್ಲಿರ್ಲಿಲ್ವಾ?
ಇದೆ.
ನಮ್ ಕಡೆ ಇದೆ, ಅಪ್ ಟು 15 ಸಿಗತ್ತೆ ನಮ್ ಕಡೆ.
15
ಸರ್ ನಿಮ್ಮಲ್ಲಿರುವಷ್ಟು ಇಲ್ಲಿ ಸಿಗಲ್ಲ ಸರ್.
ಸಿಗಲ್ಲ.
ಆದ್ರೆ ಇಲ್ಲಿ
68
ಮಂಗಳೂರಲ್ಲಿ ಏನೂ ಸಿಗೋದಿಲ್ಲ. ರೈಟ್, ಮಂಗಳೂರು ಕಡೆ ಆದ್ರೆ 69 ಇಂದ ಅಷ್ಟೇ ಸಿಗುತ್ತೆ. ಅದು ಎಷ್ಟು 3 years ಗೆ. ಆಮೇಲೆ 81 ಇಂದ ಸಿಗುತ್ತೆ. ಇವಾಗ ರೆಗ್ಯುಲರ್ ಆಗಿ ಮಾಡ್ತಾರೆ ಇಲ್ಲಿ. ಬಟ್ ಇಲ್ಲಿ ಬೆಟರ್. ಬ್ಯಾಂಗ್ಳೂರ್, ಓಲ್ಡ್ ಮೈಸೂರು ಇಸ್ ಬೆಟರ್. ವಿ ಗೆಟ್ ಓಲ್ಡ್ ರೆಕಾರ್ಡ್ಸ್.
Alright, we'll see 1374 ನೋಡೋಣ.
From 68-69 I have
68-69 ಇಂದಾನೆ ಇದೆ. And Dumana name is shown in both, in respect of both the survey numbers.
No, what is the mode of cultivation?
self. ಸ್ವಂತ ಇದೆ. Do.
Because there is no written lease, madam.
ಹೌದು.
Huh?
ಹೌದು.
Where? ಎಲ್ಲಿದೆ? Mode of cultivation ಏನಿದೆ? ಡುಮ್ಮಣ್ಣ ಯಾರು?
Dumana is the petitioner who has filed forum number 7. His father is Muniswamappa. Pitrarjita Muniswamappa anta.
Yes, madam.
So, ever since 1968-69, his name is shown in respect of 1 acre in respect of one survey number and 2 acres, 8 guntas in respect of the other survey number. And I'm not claiming the entire property because it has gone to my brothers. And that is also purchased by the petitioners under the very same auction purchase. And that is not challenged.
ಯಾವುದು?
2 acres, 21 guntas. ಅದು ಯಾರು ಚಾಲೆಂಜ್ ಮಾಡಲಿಲ್ಲ. And it has remained with the petitioners, purchased under the. But nevertheless, the sale certificate is set aside. Award is set aside.
Award is set aside, but
Yes.
not sale certificate.
Award is set aside and consequently the sale certificate goes.
They have not challenged it.
That's not challenged. Now, I would like to take your lordship to the 60 and took decision to appoint revenue inspector Jala Hobli to be there. Notice to first respondent could not be served, and I have taken your lordship to the entire. The lands are now in the possession of the second respondent. The tribunal proceeded to conduct inquiries, and that paragraph is also covered. In order to realize these two items of loans, these lands were brought to sale and put to auction on 17/4/78 by the PLD Bank, Devnahalli. And the respondent Hemanna got these lands as highest bidder in public. The sale was also confirmed by the Assistant Register of Cooperative Societies, Dodblapur, on 12/12/78, and the fact was also notified in the Gazette on 28/12/78. He further says that he has been in possession of these lands ever since the date of sale from 28/12/78. The respondent, that for the reasons quoted in his written statement, requests the tribunal to dismiss the prayer of the petitioner in their interest. On 23/2/81, the petitioner filed his written statement stating that these lands bearing survey number 4 and 6 of Sav originally belonged to the joint family of the petitioner, his father Muniswamappa, and his brothers Avlappa and Chinnappa. There was a partition of these lands on 7/9/55 amongst his co-partners, including the petitioner. And this fact is proved by the partition deed registered in the office of the sub-registrar Devnahalli on 7/9/55. The first respondent, the father of the petitioner, after partition of the lands claimed by the petitioner in this case, were cultivated by the first respondent for 2 years. This is where he cultivated after partition only for 2 years. And thereafter expressed his inability to cultivate them personally due to his old age, and leased these lands to the petitioner Dhumanna for Vara cultivation. The extent of land that was leased to the petitioner was 2 acres 8 guntas and in survey number 6 and 1 acre in survey number 4 of Satnur. These lands were being cultivated for the past 23 years by the petitioner uninterruptedly and as tenant under the first respondent. The alleged purchase of these lands by the second respondent Hemanna in a sale conducted without the petitioner, because he was not, his whereabouts were not known after 1969. And he was not, there was no service of notice with regard to the auction sale to the first respondent. Without the petitioner being made party to the proceedings, the sale held by the sale officer by the Primary Land Development Bank, Devnahalli, on 17/4/78, and the execution proceedings taken in this case by the authorities of the cooperative department, therefore do not bind the petitioner. The petitioner has denied having made over possession of this land to the respondent too, in consequence to the execution proceedings. He has further submitted that under the provisions of Karnataka Cooperative Societies Act, it is mandatory that he should obtain possession through the deputy commissioner. Because this was the tenant land, 89 of the Cooperative Societies Act demands that the possession has to be delivered by the DC, Deputy Commissioner of the district, observing the required formalities contemplated in section 89C2B of the said act. Thus, he clarifies that the possession of these properties were never made over to the second respondent who claims having taken possession of these lands. He accepts that the respondent too is in possession of the lands by virtue of the orders of the Honorable High Court in WP number 12045 dated 6/11/1979, appointing him as interim receiver till disposal of application filed under section 48 of KLR Act. The petitioner further averred in his statement that these lands were in his possession actually cultivating as Vara tenant under the respondent, and at present his whereabouts are not known. He has in addition stated, since the first respondent is none other than his father, he was not obtaining any receipts for having delivered the grain. He added the award passed by the arbitrator of the cooperative society in respect of these lands in dispute number 73 of 73/74 has been set aside by the KAT in appeal number 544. So that order has been set aside. The sale certificate, the award has been set aside in the appeal 544 of 1979 dated 11/7/1980 minutes. And it is also admitted
Yes.
he has also furnished the certified copy of the said order in appeal for the perusal of the tribunal. He has also stated that his right as tenant would sustain under the provisions of Karnataka Land Reforms Act 1961, and the respondent two, who claims his right as purchaser by virtue of sale, would be entitled only to the occupancy price for the land earned under auction sale if the same is sustained. The petitioner has also filed a certified copy of the order passed by the principal civil judge in MA number, where the prayer of the petitioner, Dumanna alias Munishamappa, for an injunction against the such property is dismissed as the civil court is barred with the jurisdiction of deciding the tenancy matter. The petitioner has mainly contended that second respondent Hemanna has no right on the land as the sale conducted by the PLD bank authorities is set aside by the Karnataka Appellate Tribunal in appeal number 544 of 79 dated 11/7/80. He also averred that the provisions of section 89C2B of the Karnataka Cooperative Societies Act 1959, which reads as under, have not been complied with by the cooperative department. This is not complied. And the 89C is extracted in the order. On perusal of the evidence adduced by the petitioner, the tribunal felt that the petitioner was in possession and enjoyment of the lands in question as tenant under the first respondent, even if the bank authority sold the lands in public auction to realize the loan amount due to these lands. The tenancy rights do exist on these lands, and the purchaser is entitled to get only the compensation payable on the said lands if the sale is sustained. In other words, the bank authorities have no right to sell away the tenancy rights existing on the lands, as it is absolutely vested with government as on, that is section 44 of the Land Reforms Act. Vesting takes place as early as 1/3/1974 when the amendment was brought into force. Now, the order says because it has vested as on 1/3/1974, the PLD bank had no powers to auction, to sell the property under auction, and therefore all the proceedings are void. Thus, the lands in question are tenanted lands on the said land, said date. The petitioner is to be registered as an occupant. These lands under section 5 of the Karnataka Land Reforms Act 19 amended. Therefore, the tribunal is of the unanimous opinion to register the petitioner Dumanna alias Munishamappa as an occupant of the said lands. It is therefore ordered to register the petitioner Dumanna alias Munishamappa as an occupant over 1 acre in survey number 4 and 2 acres 8 kuntas in survey number 6 of Satnur village, Jala Hobli, Devnali Taluk, under section 45 of the Karnataka Land Reforms Act 1961 amended, subject to payment of premium. It is further ordered to pay the entire amount deposited by the second respondent to the petitioner, being the value of crop raised by the second respondent as interim receiver of these lands, because he was the interim receiver during the pendency of forum number 7. Therefore, the order, under the order, he is directed to deposit. Now, this order was challenged before this honorable court in WP number 28672 of 1982.
This order was set aside?
Yes, my lords.
This order was set aside by this court.
by the writ petition, in the writ petition by this honorable court. Writ appeal was filed and the writ petition order was set aside. Set aside. That is also the next document, Annexure C. Annexure C is the writ petition order by Justice Bopanna at page 46 form.
Yes.
In the circumstances, para 3, last paragraph of the order, this petition is allowed the impugned order as also the order, if any, made on 13/7/82 in LRF number acquired and the matter is remitted to the land tribunal for fresh disposal of the application of respondent 1 after holding a fresh inquiry. Since the petitioner has been appointed as a receiver of the land in terms of the interim order of this court, he shall continue to act as such till the disposal, till the parties obtain a fresh order from the tribunal. This is the order of the, in the writ petition, which was again challenged by Muniappa alias Dumanna at page 52 is the order of the writ appeal 667 of 1985. This is a division bench order. Here, even in the writ proceedings, very same Ramachandra, advocate for petitioner, is shown in the cause title of the order. And even in the writ appeal, very same Ramachandra for R1.
Yes, ma'am.
And here, the operative portion of the order, page 3. In the result, the writ appeal is allowed. The order made in writ petition 28672 of 82 is set aside. The writ record stands transferred to the appellate authority constituted for Bangalore Rural District to treat it as an appeal presented against the orders of the land tribunal and to dispose of the same in accordance with law, after affording an opportunity to both the parties to adduce additional evidence if need be and of being heard. The parties are directed to appear before the appellate tribunal, appellate authority on 1/6/1987. And further, it was extended on the next page. The party shall appear before the appellate authority on 14 September 1987. Thereafter, in 1990, the appellate authority was abolished. And the CP had to be filed before this honorable court. That's how the petitioner.
Why this CP is listed before division bench in this case?
Division bench.
Then
Then it
that
was.
was the procedure.
Yes.
That was the procedure.
Yes.
Then that was the
Yes.
procedure, madam.
No, single judgment CP ಹಾಕಿ convert ಮಾಡ್ಕೊತಿದ್ರಲ್ಲ.
ಇಲ್ಲ. Division bench.
ಆವಾಗ ಅದನ್ನೇ ಅದು ಬಹುಶಃ ಅಪೀಲ್ ಹಾಕಬಾರದು
Yeah, I'm
ಮಾಡಿದ್ರು.
I appealed, we have appealed in good number of cases. CPs were converted. into
Initially, as your lordship's correct,
the
initially
single judgment ಬರ್ತಿತ್ತಲ್ಲ.
it was single judge.
Or
But
then
later some policy, I don't know, it was
they were all
being
listed
placed
before.
before the, probably to prevent appeal or something like that. Number of appeals from
ಇಲ್ಲ,
writ
ಅದು
again.
ಬರಲ್ಲ. ಅದು for limited purpose ಅದು. Only for conversion ಅದು.
ಈಗ ಯಾತಕ್ಕೆ ಅಂತ ಗೊತ್ತಾಗಲ್ಲ ನನ್ಗೂ ನೆನಪರಲ್ಲ.
ಅಲ್ಲ, but ಅಲ್ಲ CP ಅದು convert ಆದ್ರೆ those writs were heard by division bench.
Yes.
Division bench.
Yes, the order is made by a division bench.
ಹೌದು.
That is exactly what I would like to bring.
But order passed by LRRA was amenable to writ jurisdiction or writ appeal?
CRP revision jurisdiction.
ಅಲ್ಲಿ single judge.
ಅಲ್ಲಿ ಸಿಂಗಲ್ ಜಡ್ಜ್. ಅಲ್ಲಿ ಸಿಂಗಲ್
CP ಹಾಕಿ ಇದನ್ನ division bench ಹೋಗ್ಬಿಡ್ತು.
ಅದು ಯಾಕೆ ಮಾಡಿದ್ರು ನನ್ಗೂ ನೆನ್ಪರ್ತಾ ಇಲ್ಲ ಇವಾಗ.
So then you lost one right of appeal.
ಸಿಸ್ಟಮ್ ಇತ್ತು.
ಹೌದು.
Honorable Justice Rajendra Babu Mirde ಅವರು
ಹೌದು.
ಕ್ಲಿಯರ್ ಮಾಡಿ ಮಾಡ್ತಾ ಇರೋ ಡಿವಿಷನ್ ಬೆಂಚ್. I think some notification have been issued.
Some notification was issued,
Some-
all spending CPs.
ಒಂದೇ ಅಲ್ಲ, ಈ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಮ್ಯಾಟರ್ಸ್ ಇತ್ತಲ್ಲ, ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಮ್ಯಾಟರ್ಸ್ ಪವರ್ assigned to the learned single judge was withdrawn and it was assigned to the division. Land acquisition matters so ಹಾಗೆ ಆಗಿತ್ತು, land records matters so ಆ ತರ ಆಗಿತ್ತು.
All right, you can continue, madam, Monday.
Yes,
Monday ಮಾಡ್ತೀರಾ? Continue on Monday.
yes,
Monday and Tuesday, we'll see.
yes,
Conclude or we'll take it as partial and we'll hear it.
yes.
ಅಲ್ಲ ಶಾಸ್ತ್ರಿ ಸರ್, ಅವಾರ್ಡು ಚಾಲೆಂಜ್ ಮಾಡಲ್ಲ. ಇಲ್ಲಿ 34 ವರ್ಷ ಆದ್ಮೇಲೆ ಅವು ಅದ್ ಬಿಟ್ಟು ಇನ್ನೊಂದ್ ಇಟ್ಟು
ಸರಿ ಇಲ್ಲ, ಒಂದ್ ದಿವ್ಸನೂ ನಾನು ಸುಮ್ಮನೆ ಇದ್ದಿಲ್ವಲ್ಲ, ಒಂದ್ ದಿವ್ಸನೂ ನಾನು ಡಿಫೆಂಡ್ ಮಾಡದೆ ಬಿಟ್ಟಿಲ್ಲಲ್ಲ. ಓನ್ಲಿ ಮಿಸ್ಟೇಕ್ ವಾಸ್ ಡಿಸ್ಮಿಸ್ ಆರ್ ಡಿಫಾಲ್ಟ್ ವಾಸ್ ನಾಟ್.
ಎಲ್ಲಿ ಡಿಫೆಂಡ್ ಮಾಡ್ತಾ ಇದ್ರಿ ನೀವು? Award, you have that award is staring at you. You have not challenged that award.
Yes.
No, award is not against me. It is against the municipal order of the award in cooperative proceedings is against the father of the present petitioner, applicant Dumanna.
Correct. That award was set aside.
Award was set aside after 1979. The daughters file an appeal 554 of 79 stating that we are not divided. We are joint family members. I have rights over the property. And on that ground, it is remanded. I am not a party.
You are not a part.
I am not implicated. That's fair, my lord. I say fraud is there. That is.
I want view of the order passed by Honorable Justice Shailendra Kumar. There he declared that the transaction of mortgage and auction, it's a voided transaction after vesting.
Adana,
Then that
please read it once again. We'll see.
That finding is
I
confirmed
think
by the
you
division.
both together in Shastri's sir's absence, probably you read that order.
Yes, my lords. Very
What's
first.
the order with
Yes,
the
very
first-
first
on the
day.
first day, I said then nothing more to be looked into. That was the impression.
On arising out of the same issue,
All right,
now
we'll
one
accept.
more writ appeal is pending before the division bench at my instance on behalf of the present respondent.
Respondents.
ನಾನು ಹಾಕಿದ್ದೀನಿ ಮೊನ್ನೆ
ಅವರ ಅಪೀಲ್ ಹಾಕಿದ್ದಾರೆ ಅಂದ್ರೆ ಇನ್ನೂ ಕೇಸ್ಗಳಿದೆ ನಮ್ದು ಹಿಂಗಾರೆ ಗುದ್ದಾಟ. ಅದು ಇನ್ನೊಂದು ರೌಂಡ್ ಲಿಟಿಗೇಷನ್ ಬೇರೆ.
revenue entries are concerned.
ಅದ್ರ ಮೇಲೆ ರಿಟ್ ಅಪೀಲ್.
ಅವರು they are trying to get their name entered which my client is
Trying to-
resisting.
yes, ma'am.
That is all.
Our name was.
They want to get into possession, they can't get into possession because possession is delivered through lawful mode. And I have continued, I was also receiver. And then RTC is transferred to my name. I am not allowing my right to get the RTC change. That is the proceedings.
You know, section 5,
I don't.
ಈಗ you want them to file a section 5 suit.
Though, yeah, probably, I don't know.
ಅಷ್ಟೇ 5 suit ಅಲ್ಲ ಅದ್ ಬಿಟ್ರಿ ನೀವು.
ಅಲ್ಲ ನಾನ್ ಹೇಳೋದಾರೆ ಈ ಲಾಜಿಕ್ ಬಾಲಕೃಷ್ಣ ಶಾಸ್ತ್ರಿ ಬಿಟ್ರೆ ಯಾರು ಅಡ್ರೆಸ್
ರಾಜಗೋಪಾಲ್ ನನ್ನನ್ನು ಚುಡಾಯಿಸೋದು ಬಿಡಲ್ಲ ಸರ್ ಅವರು. ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ ಆದ್ರು, ನಾವು ಫ್ರೆಂಡ್ಸ್ ಒಟ್ಟಿಗೆ ಬೆಳೆದಿದೀವಿ. ಅವ್ರು ಡೆಸಿಗ್ನೇಟೆಡ್ ಸೀನಿಯರ್ ಆದ್ರೂ ನನ್ನನ್ನು ಚುಡಾಯಿಸೋದು ಬಿಡಲಿಲ್ಲ ಅವರು.
He has already put a caveat. He says that you are his good friend. So why the court should get between two friends?
ಒಂದ್ ಸಾರಿ one matter I have argued before Mohan Shantan Gowda, Andhra Pradesh. ಅವರು ಒಂದು 10 ನಿಮಿಷ ಆದ್ಮೇಲೆ he put me a question. Rajgopal, I wanted to ask one clarification ಅಂದ್ರೆ ಏನು ನಿನಗೆ ಬಾಲಕೃಷ್ಣ ಶಾಸ್ತ್ರಿಗೆ ಇಂಥ ಮ್ಯಾಟ್ರ್ ಬಿಟ್ಟರೆ ಬೇರೆ ಬರಲ್ಲ. ನಾನು ಹೇಳಿದೆ ನಾವು ಹಣೆ ಬರ ಇತ್ತೆ ಕಡೆಗೆ he only said that ಇದು ಹೆಂಗಾಗುತ್ತೆ ಅಂದ್ರೆ ಏನೂ ಆಗಲ್ಲ ಅಂತ ಫೈಲ್ ತಗೊಂಡು ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ ನಲ್ಲಿ ಕೂತಿರ್ತಾನೆ. ಅವ್ರ ಪಕ್ಕದಲ್ಲಿ ಯಾರೋ ನಿಮ್ ಪರಿಚಯ ಇರೋರು ಕೂತ್ಕೊಂಡು ಯಾಕೆ ಹೋಗ್ತೀವಿ ಅವ್ರ ಇಬ್ರ ಹತ್ರ ಹೋಗು ಏನಾರ ಒಂದ್ ಮಾಡ್ತಾರೆ. ನೀವು ತಗೊಂಡು ಏನಾರ ಕಷ್ಟ ಪಟ್ಕೊಳ್ಳಿ ನನಗೆ ಯಾಕೆ ರಿಸ್ಕ್ ಕೊಡ್ತೀರ ಅಂತ.
Correct ಹೇಳಿದಾರೆ.
It was happened in the open court.
We'll sit on Monday.
Yes, ma'am.
You can continue, madam.
Yes.
I think better to read that order once again.
Yes, ma'am.
Once you read that order, then you can cover up with the
I have
document.
to cover also the KAT order
Yes, ma'am.
under which the sale was set aside. Actually,
He
ಎಲ್ಲ
said-
cover.
Shastri sir says that only award was set aside. Your argument is that consequentially,
Once the award
Sale.
is set aside,
and then yes,
the
how to read.
sale automatically goes.
No, but please examine it
Yes,
because
ma'am.
yes, cited the apex court judgment directly on the point. It says that there a decree is set aside. Apex court says that doesn't affect the sale and sale certificate.
Yes, that
So
is under
get a counter.
EP
Rajgopal
proceedings. Agwatsu.
Please, you have to get a counter to that
Yes,
and then you read the judgment also.
yes.
Think,
Yes, sir. Yes.
my
Tomorrow.
I think my colleague is more effective than me. I may not, my presence may not be necessary. I'm much we need it, sir. Grateful.
Others matter, cell number 23. Basuraju.
ಎಲ್ಲಾರ್ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಆರ್ ಅಲೌಡ್ ಮಿಲಡ್ ಐ ವಿಲ್ ಅಮೆಂಡ್ ದಿ ಕಾಸ್ಟ್ ರೇಟ್
ಹೌದಾ? ಯಾವ್ದು ಒಂದ್ ನಿಮಿಷ
23
ಎಲ್ಲಿದ್ದೀರಿ ಗಿರಿ?
ಅದ್ರಲ್ಲಿ ನಮ್ಗೆ ಇದು ವಕಾಲತ್ ಬಂದಿಲ್ಲ ಎಲ್ಲ
ಅಲ್ಲ ಎಲ್ಲಾರ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಆಗೋಗಿದೆ.
ನಮ್ಗೆ ವಕಾಲತ್ತು ಇನ್ನೂ ಬಂದಿಲ್ಲ ಎಲ್ಲರಕ್ಕೂ.
ಇನ್ನೂ ಬಂದಿಲ್ಲ. ಯು ವಾಂಟ್ ಟೈಮ್?
ನಾನು ಅಮೆಂಡ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ಅವರು.
ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿ.
ಅಲ್ಲ, you undertook, Nagbhushan sir, you undertook to file wakalat.
ಹೌದು.
You undertook to file wakalat.
ವಕಾಲತ್ ಬಂದಿಲ್ಲ, ತಂದ್ಕೊಟ್ಟಿಲ್ಲ.
Alright, but those applications are allowed now?
ಅಲೌಡ್.
Allowed, huh?
ಹೌದು.
You have to amend the cost.
Yes, yes.
Alright, finally 2 weeks time to amend the cost.
Much of.
Cell number 24.
24.
Ms. Som Reddy. Wait, please.
No, wait.
Cell number 25.
Memo for repeating. death.
Filed a memo for reporting death of GP holder.
GP order, please. Alright, finally 2 weeks time to take steps.
26.
26. 2
Fine,
weeks,
Tribunal.
2 weeks to take steps. Aita.
27. Rajeshwara PM.
What dismissal of their appeal? Okay. Alright, none appears, list it on so and so date. ಯಾರು ಹಾಕಿದ್ದಾರೆ?
Respondent advocate. 28.
ಎಲ್ಲ ಡೇಟ್ ಕೊಟ್ಬಿಡಿ, list it on so and so date.
29.
Appearing for respondent in this case, my lords.
Date, list it on so and so date.
29. 29.
Appearing for respondent in this case, my lords, may be taken up on 15th next, my lords.
What after vacation?
20, 30.
30.
ಅದು ಅಪಿಲೆಂಟ್ ಮಿಲಾಟ್.
Respondent. My lord, is appellant during the appeal period, my lord, is appellant is died. Only one LRs is come on record. Other two LRs is not record, my lord. I filed the application for direct the,
List it on so and so date.
please.
Next.
31.
I don't, my lords. I made this application to recall the order of imposing cost. ಅವ್ರೇನೋ ಬೇಡ ಅಂತ ಹೇಳಿದಾರೆ, ಅದು ಹಿಯರಿಂಗ್ ಆಗ್ಬಿಡಿ, ನಂದು ಅಲೋ ಮಾಡಿ. ಅಲೋ ಮಾಡಿ.
ಏನದು DNP ನಾ?
ಕಾಸ್ಟ್ ಕೇಳಿದಕ್ಕೆ ಕಾಸ್ಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಎಷ್ಟು ಕಾಸ್ಟ್ ಹಾಕಿದ್ರು?
5,000
ರೂಪಾಯಿ ಹಾಕಿ.
ಯಾಕೆ?
ಅದು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಅವತ್ತು ಜೂನಿಯರ್ ಬಂದು ಕೇಳಿದ್ರು ಮೈ ಲಾರ್ಡ್ಸ್, ಅದಕ್ಕೆ. We have no objection.
Calling. Council appearing for appellant has filed an application to recall order dated 4/9/24. This application is not seriously contested by the council appearing for contesting respondent. Accepting the cause, this court is inclined to recall the order. ಅದನ್ನ modify ಮಾಡಿ 5 ಮಾಡೋಣ, completely recall ಮಾಡೋದು ಸರಿ ಕಾಣಲ್ಲ.
ಅಲ್ಲ, ಅವ್ರು ಬೇಡ ಅಂತ ಹೇಳ್ತಾರೆ. ಮಾಡಿ ತಾವು ಮಾಡಿ.
500 payable to whom? 5,000 payable to whom? ಯಾರಿಗಿತ್ತದು?
ನಮಗೆ
Respondent.
ಅವ್ರಿಗಿತ್ತಾ? 500 payable to, ಯಾಕೆ ನೀವು ಯಾರು ಇರ್ಲಿಲ್ಲ ಅಂತ ಅದು ಕಾಸ್ಟ್ ಹಾಕಿದ್ದ?
ಇಲ್ಲ, ನಾವು ಇದ್ದು ನಮ್ಮ ಕೊಲಿಗ್ ಕೇಳಿದ್ರು ಅದೇನು ಕಾಸ್ಟ್.
Then record in entirety. Record, yes.
Final hearing postponed.
List it in final hearing on.
In fact, I wanted to argue before your lordship, this is not.
Any date may be given, my lords.
KLR land reforms RFA all are ಕಷ್ಟ. ಆದ್ರೂ ಮಾಡಿದ್ವಿ ನಾವು, 2 ದಿವಸ ತಗೊಂಡು ಮಾಡಿದ್ವಿ, ಅಷ್ಟಾಗ್ಲಿಲ್ಲ.
ಆಗ್ಬೋದು.
Lords, any date.
Next.
Krishna.
I'm appearing for the appellate in 32.1, my lord.
Yes.
I filed an IA to bring on record the LRs of respondent. Respondent has passed away, my lord. on
Notice have to go
Notice has to go, my lord.
in both the appeals or
Uh,
only the first appeal?
Only in first appeal, my lord.
All right, issue notice on IA2 of 24.
Please, my lord, in 32.1, my lord, the appellant has passed away and I filed the death certificate of the appellant, my lord. They have not taken any steps. The advocate.
When he died,
26/4/2024, my lord.
26/4/2024.
4/2024.
Abet
It's been
aita.
7 months agide, my lord.
You have filed a memo to that effect?
Please, my lord, on 3/9/2024, I have placed the death certificate on record.
Still appearing for respondents, contesting respondents, has filed a memo reporting death of appellant. Perusal of the memo, this court has noticed that appellant has died on
26/4/2024.
2024. No steps are taken to bring. Agattalla. Yes, 7 months aita.
My lord,
26/4.
26/4.
26/4, my lord.
Abet aitalla.
Abet agide. April 2024, my lord.
Beyond 90 days abatement.
Beyond 90 days. It's been 90 days, my lord, more than 90 days.
The appeal is abated as no steps are taken to bring the legal heirs of sole appellant. Accordingly, appeal is dismissed as abated.
Please, my lord. In, my lord, date may be fixed for 32.1, my lord, my appeal.
All right, listed in hearing on so and so date.
Notice, sir.
Notice, sir. On IA number 2 of 24.
Okay. Oh, the notice aitalla.
Notice agide, my lord. Any date may, my lord, for returnable.
Listed on so and so date.
Not further, my lord, I have filed NOC wakalat. The previous counsel has filed memo of retirement, my lord. The causes, the earlier counsel's name is showing. It may be kindly.
So, Bariri. Raised office is directed to delete the name of earlier counsel who has already filed a memo for retirement. So and so has filed wakalat.
Please,
Raised it to reflect his name.
please, my lord. Much obliged. Nagaraj. 32.2 abet agide. Abet agide. Second. ಇದರಲ್ಲಿ ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿದೆ ಸರ್. Point 1.
Court officer, list 3 ದಲ್ಲ ಏನು ಸರ್? ಸರ್, ಲಿಸ್ಟ್ 3 ಎಲ್ಲ ಆಟೋಮೆಟಿಕ್ ಅಡ್ಜರ್ಮೆಂಟಾ?
ಡೇಟ್ ಕೊಡ್ರಿ.
ನೋಡಿದ್ರ ಕೊಟ್ಬಿಟ್ಟು ಇದೊಂದು ಕರೆಕ್ಷನ್ ಆಗಬೇಕು. ಅದೇ ಮೇಡಮ್ ಆರ್ಸಿ ವಾಕ್ ಮಾಡ್ತೀವಿ ಅಷ್ಟೇ, ಫ್ಯೂಚರ್ ಇದು ಮಾಡಬಾರ್ದು ಅಂತ.
Concerned officials are hereby warned not to repeat the same in the future.
ಸೀರಿಯಸ್ಲಿ ಅಂತ ಹಾಕಿದೆ, ಇನ್ ಫ್ಯೂಚರ್ ಅಲ್ಲಿ ಮಾಡೋದು ಸ್ಟ್ರಾಂಗ್ ಆಗಿ ಒಂದು ನೋಟ್ ಹೋಗ್ಬೇಕಲ್ಲ. ಅಲ್ಲ ರೀ, ಅದು ಆರ್ಜಿ ನೋಟಿದೆಯಲ್ಲ, ನೀವು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು ವಾಕ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಅಲ್ಲ, ಅದು ಇದು all certified copies or photocopies of the trial court record furnished by the counsel for the appellant is kept on the record. After vacation. Ravi ಅವರೇ, ಅದ್ರಲ್ಲಿ ಶ್ರೀನಿವಾಸ ರಾವ್ ಬ್ಯಾಚ್ ಕೇಸ್ ಹಾಕೋ ಬ್ಯಾಚ್ ಅಲ್ಲಿ ಸಿಗ್ತಾನೆ ಇಲ್ವಲ್ಲ ಅವರು. ಈಗ ನೋಡಿ ಐಎಗಳು ಹಾಕಿಲ್ಲ ಅವರು, ಏನ್ ಮಾಡ್ಬೇಕು? ಲೀವ್ ಟು ಪರ್ಮಿಷನ್ಗೂ ಹಾಕಿಲ್ಲ, ಲೀವ್ ಟು ಅಪೀಲ್ ಡಿಲೇರಿಗೂ ಹಾಕಿಲ್ಲ. 44 ಮಾಡಿ ಏನ್ ಮಾಡೋದು? ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೋಗ್ಲಿ, ಯಾರೋ ಒಬ್ರು ಮಾಡಿದೀರಾ, ಅವ್ನ ಏನ್ ಮಾಡ್ಬೇಕು ಈಗ? TNC ಮಾಡ್ಬೇಕು.
I'm Ranga Karnam. I'm 10x certified in AWS, Azure, and Google Cloud as well. Our courses are helping thousands of learners do their cloud certifications in AWS, Azure, and Google Cloud. In this video, let's learn AWS. We will take a simple example and understand all the different services which are present in AWS. We'll be exploring more than 50 different AWS services with this specific example. Are you ready to get on a ride to learn AWS? Let's get started. The example we are going to use is a very, very simple application, right? You have a front-end application, which is talking to a REST API, which is fetching the data from a typical database. And you also have a reporting workflow. Let's not really worry about the reporting workflow right now. Let's start with thinking about how we can actually implement this specific front-end application talking to a REST API, talking to a database. This is typically called a full stack application, right? So how do we implement this in AWS? That's the first thing that we would start with right now. Now, let's start with focusing on the REST API part of it, right? You'd want to deploy a REST API to AWS. Let's say this is a Java application or a Python application or a Node.js application, which is part of your REST API. What do you need to run your specific REST API? Let's say you are running it in your data center. Typically, what you would need is something called a virtual machine. You would need some kind of compute to be able to run your application. This is what is called a virtual machine. Will just one virtual machine be sufficient? What if this virtual machine goes down? Your application will go down. And that's why in the cloud, typically you will not just have one virtual machine. What you'll have is a group of virtual machines. So you'll have a group of virtual machines where you would deploy your application to. And when you have a group of virtual machines, what do you need? You need to be able to load balance between them. So you need to set up a load balancer to load balance the requests between all these things. So you need to have something on top of this. This is nothing but a load balancer. So all the requests from the user would go to the load balancers. And then from the load balancer, they would flow down to your VMs or the virtual machines. On this virtual machine is where you can deploy your application. Maybe if it's a Python application, you would install Python and then deploy it in there. This is kind of a simple architecture you can get started with. And if you're implementing this kind of an architecture in AWS, what you can make use of is something called EC2, Elastic Compute Cloud. Elastic Compute Cloud is the compute service in AWS. And if you'd want to do load balancing, what you would need to do is to use something called Elastic Load Balancer. Elastic load balancer will help you to load balance between different EC2 instances. One of the things that we have seen in here is the fact that we would want to create a group of EC2 instances. We want to create a group of virtual machines. How can you do that? To be able to create a group of virtual machines, what you would need to do is you would need to actually make use of a concept in AWS called auto scaling group. Typically, when I just need to create one virtual machine, EC2 is sufficient. Elastic Compute Cloud is sufficient. However, if I would want to increase the number of EC2 instances, if I would want to create a group of EC2 instances, that's when I would go for an auto scaling group. And you would use an elastic load balancer to distribute the load among different EC2 instances which are part of an auto scaling group. So that's how you can deploy your REST API to AWS. One of the things that you can do is you would want to increase the availability of your application, right? What if this specific VM goes down? If this specific VM goes down, your application also goes down. And you don't want your applications to be down. Your application should always be available to your users. How can you ensure that your applications, your VMs which are deployed, don't go together down, right? They should not go down, both of them together, all of them together, right? So that's the reason AWS provides you with concepts called regions and zones. What are regions and zones? Let's write them down. Regions and zones. What's the concept behind regions and zones? Typically, whenever you have an enterprise, maybe they have just one data center. If you deploy all your VMs to this data center, if this data center goes down, your application goes down completely. And that's the reason why you don't want to deploy your VMs to just one data center. You might want to deploy your VMs to multiple data centers, and you don't want to deploy to data centers in a single region, right? This might be, let's say, in London. You don't want to deploy just to London. If you want your applications to be highly available, you'd want to be able to geographically distribute them as well. Maybe you'd want to set up something similar in New York as well. So you'd want to have something in London, something in New York, something in Sydney, something in Mumbai, and you'd want to create your VMs in there. So this is just the concept of regions and zones. In AWS, each of these, London, for example, New York, for example, maybe there are multiple other regions as well. AWS offers around 26 different regions around the world. What these regions allow you to do is to deploy these VMs in different parts of the world. Thereby, your applications don't go down. Even if the entire geographic location is going down, even if your data center completely goes down, your applications are still available. So what a ASG allows you to do is to distribute your EC2 instances across multiple zones. So in a single region, you can deploy your EC2 instances across multiple zones. Now, one of the things that you would have been seeing until now is the fact that there is a lot of complexity that is associated with setting up a simple thing. All that I'm doing in here is I want to set up a REST API for a Python application. And already we are talking about a lot of different concepts related to AWS. We are talking about EC2 instances, ASG. We are talking about ELBs. We are talking about regions, zones. You might be wondering, why do I need to worry about all this? Do cloud providers make it simple for me? Yep, the cloud providers do make it simple for you. And that's where you can go for some of the managed services which are present in the cloud platforms. Instead of creating EC2 instances manually, instead of creating auto-scaling groups, instead of creating elastic load balancers, you can tell AWS, hey, AWS, this is the code I would want to deploy. If the number of requests come in, if a high load of requests come in, then increase the number of instances. If there are less requests coming in, then decrease the number of instances. Can you do that automatically for me? I don't want to worry about installing Python. I don't want to worry about installing my application on each of these VMs. That's a lot of work for me. I don't want to worry about those operational details. I'll just give you something like a jar or a WAR file or a Python deployable unit or a container image. And can you deploy that for me automatically? And can you manage everything for me? That's where managed services come into picture. the managed services which are present for compute in AWS. If you just want to set up a simple setup like this, if you want to like create a load balancer, distribute the load between multiple EC2 instances, in those kind of situations, you can go for this specific service in AWS called Elastic Beanstalk. With Elastic Beanstalk, all that you need to specify is, hey AWS, can you take this piece of code and can you deploy this in such a way that this is deployed to these many instances? You can also configure auto scaling. Basically, you can say increase the number of instances based on the load and decrease the number of instances based on the load as well. So that's Elastic Beanstalk for you. It's a managed service for compute in AWS. You don't really need to worry about setting up the load balancer, setting up the auto scaling groups, setting up the metrics for it, setting up the EC2 instances. You don't need to worry about what runtime needs to be available on the EC2 instances. You don't need to worry about that. All that you need to do is to go to Elastic Beanstalk and say, I would want to deploy a Java application. Here is the jar or a var. Here is the container image for it. And Elastic Beanstalk would run it for you. So if you have a simple application, simple Java-based, Python-based, Node.js-based, or any other language-based application, you can use Elastic Beanstalk to deploy it to AWS without worrying about managing it. You don't need to worry about availability, scalability. You don't need to worry about increasing the number of instances and things like that. Elastic Beanstalk takes care of everything for you. One of the other important evolutions in the last few years is the evolution to Docker containers, right? Instead of actually trying to create a VM with multiple layers, right? So whenever we are trying to set up an application in the VM, there are a lot of things that you need to set up. First is the underlying infrastructure of the VM. Let's not really worry about it. On top of it is where your OS is. On top of it is where your application runtime. If I would want to have Java application, then I would need to create a Java runtime. And on top of it is the code. You'd also need to be able to configure environment variables and things like that, right? So deploying an application typically involves a lot of different steps. So if I want to deploy something to a VM, there are a lot of manual steps involved. And to avoid that, we started going towards containers. So we started going towards a container image. So instead of doing this on the VM, what we can do is we can create a container image. And the container image contains the OS, it contains the runtime, it contains the configuration you'd need, and it also contains the deployable unit or the code which you would want to be able to run. And once you have a container image, you can go ahead and run this anywhere. You can run it on your local